Pardon to make a mention, my lord. This is a review application. Date is fixed for Monday to take physical possession of my property. On the basis of the bank and the auction purchaser could not brought to the notice of this honorable court that the loan was completely closed. And in the closed loan, the auction was conducted and thereafter interfered by the DRAT and remanded the matter to the DRT. But the writ petition was allowed and directed a review application to let it be taken up tomorrow, my lord. No, because your lordships have passed the order, it has to be taxed. It needs to be, my lord. Monday is also, my lord, closed, declared holiday, my lord. Date is fixed for Monday. My lord?
The function, sir.
My lord, after lunch. After lunch.
Are you ready to show one of it?
Yes, my lord. The bank has given an NOC.
That's afterwards. Now, before us, can you make a reasonable amount?
My lord, already don't close, my lord.
That's what you are saying, you are repeating. You understand? You are not there in kindergarten.
My lord.
Yeah.
No.
We want to be, but we cannot. Something should not be. It gives an impression to all them that.
No.
Very good on that.
3 p.m.
The repetition
is a violence to a sensible mind.
Sorry, my lord.
That's all.
At 2 o'clock.
Yes, ma'am.
In the meanwhile, you confer with your client as to what we have said now.
Okay.
Item 1.
I'm holding a memo. It's a single bench matter of the lordship. I have filed an application for recall. That's all.
Recall.
Yes, your lordship. Grateful, my lords. Grateful.
Yeah. Item 1.
Covered matter, my lord. It is a covered matter, my lord. So,
Covered matter.
Yes. I annexed the affidavit in affidavit page 55 and 56, as well as 54. They are already implemented to other similar situated persons like the respondent after the Honorable Apex Court's order.
That Pavitra Mohana Das.
No, my lord. That is in Punna Chandra Chand's case. Punna Chandra Chand case.
Pavitra Mohan Das case is something different.
Yes.
Different. It is, my lord, this case is covered by the Pavitra Mohan Das case of the Supreme Court. In Pavitra Mohan Das's case, they have denied that the in-charge headmaster shall not claim any salary for the post, my lord. In-charge headmaster, those who are approved. But here, this order was passed without taking into account the judgment.
Petition.
This is an apex court's decision. There was two full bench judgment referred to larger bench, which was then carried to Supreme Court. Supreme Court in Pavitra Mohan Das's case said that the in-charge headmasters, they cannot claim salary of the post. They are in charge. At best, my lord, while okay.
Sit down.
Yeah. My lord, while disposing of this writ application, my lord, Lord and single judge, they have not taken care of this Pavitra Mohan Das's case. They have taken care of Silvaraj versus another case of the Supreme Court of 99. This is subsequent to that. And while citing this judgment, my lord, their lordship have also reviewed the orders passed in some of the cases I had cited, my lord. They have also reviewed. He himself was also reviewed some orders. And so far as this case is concerned, review application was filed because prior to taking up the review application, matter was carried to Supreme Court. Supreme Court dismissal of the Supreme Court dismissed the SLP. Citing that, my lord, the review application was dismissed filed by the state was dismissed. Thereafter, this writ application was filed before your lordships. Lordship may kindly have a look to the review. Review petition 36
of 2016.
Yes.
No, which judgment said there are two things.
My lord.
In service jurisprudence, which Ramadesh refers,
Yes.
in paragraph, hey, do you have Ramadesh services under the state? Ask them to, tell the librarian to bring it immediately to the court, running. Ramadesh says, in charge arrangement, independent charge arrangement are known to service jurisprudence.
Yes.
An in-charge arrangement or independent charge arrangement or additional charge arrangement does not amount to promotion.
No.
It is for meeting the exigency of administration.
Exactly, my lord.
Therefore, persons holding the office on in-charge basis are not entitled to regular pay scale.
Regular pay scale.
Admissible to that office.
Yes.
However, they are entitled to charge allowance.
Yes, charge allowance.
Officiating allowance.
Officiating
Because they
allowance.
officiate that.
Yes. 56 or 57 of the service codes.
Yes, that is also.
96, sorry.
So, but if the rule otherwise says that even in charge people should be given the pay scale, then they are entitled. But you are saying that there is no such rule, contra rule.
Yeah.
They are entitled to charge allowance.
Charge allowances.
Whether
Our service code says that.
service code says that.
Yes.
But which judgment of the apex court your friend is relying upon? Have you seen that?
That is,
How that appears to be contra what he says appears.
that is Silvaraj versus Lieutenant Governor of Island Port Blair
This is the
and others. 99 Supreme Court 838.
and if people worship permit
Delhi, another judgment is
in the maintainability ground, the rate appeal is not maintainable against a review order, unless the judgment of the Honorable Apex Court.
After review, all right.
Yes.
Against the original order?
No, original not challenged, my lord.
yes.
It is maintainable. The not original order challenge. In the maintainability ground, my lord. Para 4 of this judgment.
So that was a case where he was posted with salary, with pay scale. Therefore, Apex Court said, you have posted him with pay scale, you have to pay.
Yes, Minister.
But where is the show that you are posted with the pay scale? It was a case in para 3 of the judgment. Therefore, I was wondering, how can that there be such a judgment? That was a case where he was given the post of additional, the charge of the case on temporary basis, not on in-charge basis.
No, my post is approved as in charge.
In charge. Therefore,
Yes.
you are not entitled.
No, there is a scale of payment. For
in
that,
charge.
for that reason,
No.
for that reason, my lord, a batch of cases are filed before your lordship. Division bench passed the order. Your lordship, my affidavit in addition, my affidavit, your lordship can see
Paying.
in the division bench, page 15.
All right, what it says?
Pass same order. This order in respondent one the order that is also in the main case, my lead case. Thereafter, they have gone to
Where is that case?
annex hereby to 2 page 15. My affidavit.
Purnachandra Chand.
Yes, ma'am. This basing upon this order, order was passed in my case, ma'am. That is page 11. Same case. Same order passed.
Concepts of wronging, minds of merit, etc. is in.
After this order, they have gone to Supreme Court. Supreme Court, my lord, dismissed with the liberty to file a review. The review also, my lord, conforms to division bench, my lord. That is annexed A by 3 series, last paragraph, my lord. Some extent modified that page 51 you also can see in my affidavit. It was. The petitioners are also paid the salary to the opposite party in the scale of a headmaster from 110-2001 onwards, during which period he has been functioning as in charge headmaster in Shiksha Niketana, having the eligibility criteria. That is the modified one. After this order, they have again go to Supreme Court. Supreme Court also confirmed that is in annexer, that in that case, page 53. Starting from 52, we are not inclined to interfere with the interim judgment, though we have reservation certain portion relating to the law procedure. For the reason that the respondent was working at a post of headmaster even before the school was granted by the appellant state of Orissa. The respondent had acquired B qualification in 94, and he has been granted a scale of applicable headmaster from 2001, after 7 years. Thereafter, my lord,
But that's what. Acquired in 1994, and he has been granted the pay scale as applicable to the headmaster from 2001, that is after completion of 7 years.
yes,
To today, that point has not formed, but for that it was. We have felt the education not here. Therefore, we have done that. This question of life. Question of lie is not settled.
thereafter also thereafter, page 54, they have implemented to this person.
That's not it.
Again, my lord, a batch of persons, you will also finally see page 56 recently, my lord, that is dated 28/10/2025. They have sanctioned and released 23 persons, my lord. That is in the 56. But ignored to me because of case is pending.
See, all over the country, 50-year jurisprudence says a person holding in charge post is not entitled to salary. He is entitled to charge allowance. Suppose, then what is the fun in having that rule 77? Let us read the rule 77.
96.
96, sir.
96.
But the apex court refers to rule 77 of which? Of that particular organization. And the question
77
of
of
law
the
is kept open.
boards.
Division bench has kept open the question of law.
Boards
Apex
legally,
court has
that is.
kept it open as it is.
Boards regulation.
Thereafter,
No, we do
also,
not agree. We do not support that.
recently, my lord, 2 months back,
Right.
they were released, my lord.
Huh?
They have released the salary. The other
They should
persons.
not. The
96.
salary, the exchequer of the state would become empty.
96, my lord, I am placing. Holding or officiating 2 or more independent posts at one time.
Ah.
The pay of a government servant appointed by the state government to hold substantively as a temporary measure or to officiate in 2 or more independent posts at one time shall be regulated as follows. A. The highest paid.
1 second. The Rama Jai's judgment, the write-up is reproduced by Karnataka High Court in Basavaraj Thotra versus Managing Director. Take out that. Basavaraj Thotra. The Rama Jai's, I had argued that matter. I said, okay, I remember. That was reproduced. Rama Jais is reproduced in that judgment. Take out that if you do not have, your library does not have good book sets. What you should do with your library? or independent post at one, but it's office, correct official. Therefore, for each purpose may draw such reasonable pay, in no case exceeding half of the presumptive pay. ILR 2004-5-6, 4-5, Karnataka. Justice Najir judgment. Honorable Justice Najir judgment. No. Basavaraj N. Dhotrad, THOTRAD.
You got the decision of Pavitra Das.
Yes.
Pavitra Das is also taken into care in the review judgment.
Pavitra.
But that deputy document, I have not researched.
Can anybody Google out that judgment? It is there. You are not properly. I remember. My memory does not much do with me. This is the judgment. Correct.
The salary by one.
Is ILR? Correct. This is the judge. This is what I had argued. Take out Basavaraj N. Dhotrad versus Managing Director, Lenders Corporation, or the question of law was kept open by the coordinate bench. Therefore, coordinate bench's view cannot be the best.
For your Supreme Court's order, the reputation also modified. Very any reputation. The order modified to extend after 7 years of teaching experience. So the respondent is now eligible from 2001. And in similarly situated persons,
You have said it 10 times now.
then they have released my lord.
That's what you have said 10 times now. Repeating the fact will not enhance the quality of performance. Yes. ILR 2006 Karnataka 163. 3163. That says, and this is affirmed by the Supreme Court, it says, an in-charge holder officiating employee cannot claim the pay scale admissible to the post which he is holding on in-charge or independent charge basis. But thing is, how are you maintaining the appeal? He is raising the issue of maintainability because you have not challenged the original order. You have challenged the review order.
Review order, yes.
Then what we can? We cannot lay down the wrong law.
My lord.
That apart, you have implemented the order in respect of others. How can you be selective? Therefore, without deciding law,
My lord.
we will say because it should not become a law for a whole state,
Yes.
for in respect of other employees also.
I shall file an amendment to the.
No, not yet this time. When the order was made,
It was way back.
you cannot make amendment. You have to challenge order itself. We do not know what we will do.
Was it 2023?
Yes.
Yeah, no, that was.
Can I pray for a leave?
Point.
Can I pray for a leave
What?
for filing appeal?
No, no question of very deep provision for granting.
No,
So
it is not there also.
We cannot grant. Take down. example, state and its officials or have filed this in private.
Last paragraph. Please.
Right.
No. It is there in Pavitra Mohan Das's case.
No, that's all. Question is maintainability.
Yes.
Point is appeal. He is entitled to argue all the points.
Yes, yes.
Before he is making. Being aggrieved, being aggrieved by a learned single judge's order dated 6/10/2023, whereby their RVWPET number 36 of 2016 has been negative. First one. In the said review petition, they had called in question the same learned judge's order dated 27/8/2015, whereby respondent employees WPC number 15538 of 2015 having been favored, a direction was issued to the appellant to pay to him or her.
Him.
Because you don't use Srimati, Shri, Mr. Nothing here in your state. No culture. But you return? Pay direction to pay him the salary in the admissible pay scale of the post of headmaster, office for post of headmaster. First of. Next paragraph. Learned AGA, Mr. AGA, drawing our attention to the text of Rule 96 of
Service Code.
Orissa Service Code. Yesterday you have to change that. You have changed what? Orissa Service Code tells that an officiating employee by way of in charge or independent charge is not entitled to the admissible pay scale of the post which he holds by that way, although he may be entitled to 50% of the presumptive pay or such other admissible allowances. First of all, he also tells us that a 6-decade service jurisprudence of the country has settled the position that placing an employee in the higher post by way of in charge, independent charge, or additional charge, it does not amount to promotion, and therefore pay scale of the post in which employee is placed as such does not avail to. First, in support of this, he relies upon a decision of Karnataka High Court in P.N. Putra versus so and so ILR 2006 Karnataka 163. First. Next paragraph. Learned, kindly be seated. A counsel representing the respondent employee vehemently contends that the intra-court appeal of the kind is not maintainable against a review order of a single judge. Wait, which is that decision? Which said review appeal is not maintainable?
2029 Supreme Court 815.
Is it from Orissa?
No, it is from Delhi, Municipal Corporation of Delhi.
But it depends upon what our rule, our laws are. We are not governed by Delhi Sultanate.
Decision.
What? It all depends whether appeal is maintainable or not depends upon our rules, which create right of appeal. Where is our rule? Any decision of our High Court saying for on review the appeal is not maintainable? Anybody?
There is no such decision.
There is no such decision.
is there.
Which is that rule? Which of appeal is filed under which rule? Let us read the text of rule now.
High Court. High Court.
High Court notice. Mr. G, just look into. These are day-to-day affairs, no?
That is FO against Abone. That is different. That is
Under the Education Act, 24B and 24C.
Yes.
24B.
Of the Education Act,
Huh.
that if against a order, it appeal is not maintained.
Maintainable. That judgment.
That is judgment of-
Which we have held that
Yes.
case. I have held that.
That Ratha case,
That is another
Narottam.
No, full bench judgment
saying
that against FAO,
Appeal is not maintained.
writ appeal.
But that is FAO.
That is FAO, governed by Education Act
But
1969
this
or
is-
something like that.
But this is writ application.
That's all right. Which is the rule? Under which rule we have filed the appeal? Let us give that. We'll settle the point once for all.
Clause 10.
Let us read the letters patent.
Clause 10 of the letter patent appeal read with Article 4
Huh?
of the Odisha High Court.
Let's read that. Read that. How that read.
Chapter 8(2).
Chapter 8 2, my lord. Yes.
Read that. Give that.
So देखो जी.
Because we don't want to lay down wrong law. You can't, we are not governed by Delhi Sultanate. We are governed by Orissa.
Orissa.
It's a federal state. Let us see what the rules say. No, can anybody do a little research and help us? Order 1948. This itself. Yesterday.
High Court. Clause 10. Chapter 8. Chapter 8, Clause 10, Article 4. Read with Chapter 8 of the Rule 2. Rule 2. Chapter 8, Rule 2.
Maintainable. without laying a challenge to the original order whereby writ petition was dismissed. First off. He also tells us that in respect of 22, how many employees? It is already given.
23 to 23 man.
In
23
respect of-
including the lead case petition. 24.
In respect of as many as 23 employees, already such a benefit has been granted, as was directed by the learned single judge in the lead case, that is WPC number.
That is WPC number 456 of 2013.
456 of 2013 between
Purna Chandra Das and versus State of Odisha.
so disposed of on
Disposal of all.
so and so. Whether that was affirmed by the division bench.
This is a division measure. That is 24/4/2013 order dated.
Similarly, circumstanced employees already benefit of the kind has been conferred, has been granted in terms of a coordinate bench decision dated,
24/4/2013.
entered in WPC number
456 of 2013.
between
Purna Chandra Chand versus State of Odisha and others.
and therefore, whatever be the arguable merits, this appeal should not be entertained. Next paragraph. Having heard learned counsel for the parties and having perused the appeal paper, we do not propose, we decline indulgence in the matter, broadly agreeing with the submission made by the learned counsel representing the appearing for the respondent, keeping open the question of maintainability of intra-court appeal for being treated in an appropriate case. Since assistance of the bar in this regard is frugal, to say the least. First off, when a set of employees have been granted a benefit pursuant to a division bench judgment affirmed by the apex court,
Yes.
affirmed by the apex court in
SLP number 1080 of 2022.
slowly. We should write
Slowly, SL
80 2022.
He does not come from our steno, does not come from Oxford. He has arisen from you people only. That's our problem. Yes. But between
Purna Chand,
Purna Chandra Chand, State of Odisha versus Purna Chandra.
State of Odisha versus
reverse that. Wide order dated
4/2/2022.
what you have written now?
No, State of Odisha versus
No. First one is Purna Chandra. Then it goes to Orissa. 20. And the same has been affirmed by the apex court in SLP number.
Yes, repeatedly.
Just to draft it, everything. The notice, sorry, note substandard is everything. Note comma. We do not subscribe to the view now canvassed by the learned HEA for setting aside the impugned judgment of the learned single judge. First, the state cannot practice discrimination for its employees because of constitutional injunction enacted in Article 14 and 16, Articles 14 and 16 of the Constitution of India. First, that apart, state is constitutionally ordained to function as a model employer wide. Bhupendranath Hazarika versus 13 SCs versus. First. Next one, with the above observations, this appeal being devoid of merits is liable to be rejected, and accordingly it is. First one, the order of the that single judge shall be given effect to within an outer limit of 8 weeks. Otherwise, it carries interest at the rate of otherwise the amount payable to the appellant respondent employee carries interest at the rate of 1% per mensem for the first 1 month and 2% for the period next following.
Item 2. No, on behalf of Mr. Patil, just running this is my question.
In item 2, yesterday another matter was there, your lordship kept it to 23rd of March. We shall file a complaint.
That was 23rd. Yeah. Next.
Item 3.
The 23rd for compliance?
Yes,
You said yesterday.
yes, yes.
That we shall report 23rd. Since learned AGA, Mr. G submits that the order in question shall be scrupulously complied with in spirit, letter and spirit. First of all, non-compliance may compel us to compel the violator to come before the court
Yes.
for offering explanation.
Item 3.
Yes.
Petitioners are running children institution in the name of various residential colleges. They are imparting clause 2 and clause 3 courses. In the year 2018, because of their financial need, they had a very the loan facilities from one finance company, that is Dirumani
Alright, we don't want that.
my lord,
2018 law.
18. My lord, there are
How much?
1,44,000, 144 lakhs, my lord, 1 crore 44 lakhs.
Yeah.
Thereafter, COVID came in and the institutions financial.
COVID came in
2019, my lord.
19 December.
No, after that, they were paying the EMI, and 2019 they could not pay because of the pandemic. And
COVID 19 pandemic came in December 2019
19,
in Wuhan.
my lord.
Yeah.
Thereafter, they
No, but you tell from which date loan is not paid.
Your lordship may kindly see 13 to notice I have annexed. They have raised a demand of.
No, that's all right. We are asking you, what was the rate of loan installment?
That agreement I have not filed here.
But you have to tell that, na?
My lord, straight away I am taking your lordship to annexal 130.
No, we cannot go that way.
My lord,
We have to go step by step. There is a methodic way of judicial process.
let me clarify, my lord. I have approached your lordship against the order of section 14.
We cannot.
And admittedly, they have not responded to 13.2, 13.4, and 30. In section 14, the collector has passed an order directing the concerned official to take possession and hand over to the finance company. Before that, only 2 things I want to appraise your lordship. This finance company, namely Tirumani Finance Company based at Bangalore, they are having their branch office at Bhubaneswar. They had advanced this loan. Your lordship may kindly look at page 40. What for? That is the amount they had advanced. Admittedly, 1 crore 40 lakhs they had advanced. Then they could not pay the installment and they issued this notice. And 13-2 also, thereafter also within 60 days, they could not pay because I can't improve. So thereafter, the other notice came under Annexure 2, my lord. These company, the petitioners had taken 2 loans from the same company. Under Annexure 6, the one loan was totally closed down by paying rupees 62 lakhs. You also may kindly have a look at Annexure 6.
But we are not concerned with that too.
From the same finance company. My lord.
That makes no sense. Each loan is a separate contract.
Yes, my lord, I am conscious of that. But the only thing is that after Section 14 order, or while it was pending, the petitioner institution made a sincere appeal to the finance company. Give us an opportunity for one-time settlement. We want to close down like the other loan by the end of July 2026. That is my limited intelligence which I am seeking here. Because Section 14, I have made it clear in your lordship has limited jurisdiction. But I am seeking indulgence from your lordship under Annexure 8. And before that also I have appealed the finance company to give us an opportunity to settle down the loan at once. Only we are asking for some time. Annexure 8 is the application of our representation. And before that also, while the matter was pending before the collector.
How much money is now payable?
My lord, they have claimed 1 crore 55 lakhs.
55.
My lord.
When it was?
That was in 2019, my lord.
Now you are not telling. Loan always bulgions. Size increase.
I am appearing for the caveat for Stock Limited.
Yeah.
The outstanding amount is now 6 crores 74 lakhs 95,650.
Are you agreeable to pay 1/3 of the loan amount?
The lord should kindly call it on 10th. I will take this.
What for? No. If you are ready, otherwise we don't need your consent for dismissing you. We propose particular things in a paternalistic way. You have been seeing us how we function in loan matters. Taking loan is easy.
My lord.
When it becomes liable to be paid back, difficulty arises to everybody.
My secured asset is there, my lord.
Therefore, they are selling.
But yesterday only I received an instruction. They have taken possession more than what is there in the secured asset.
You give back that money.
No, immediately a complaint was lodged before the collector.
No, see, these things, instead of paying the money back,
My lord,
you will lodge a complaint against the lender.
because
That
the
is
other
the-
right to property, my lord, the other assets where 8 rooms are there which is not there in the schedule. The
Not in the unscheduled property. also
unscheduled
taken.
property they have taken over.
Which one?
My lord, 16 rooms are there in the secured asset in the land and building. Whatever is there in the schedule, I can't question because that has been given as a mortgage. But over and above that, in the rest portion where 8 rooms have been left.
To argue this,
My lord.
the foundational document you have withheld from the knowledge of the court.
No, yesterday only I received instruction.
We do not.
I'm submitting that. On instruction. I
How
am
could you say this? You have filed this case. When did you file this case?
My lord,
The copy has not been served on us.
The question arises only if we want to give some order against you. We are not proposing that. Where is you are saying the property possession of which they have taken is not part of security.
yesterday only that happened.
We do not know. To say whether it is part of security or not, what is the basis? Section 91 of Evidence Act says, where some instrument is compulsorily registrable and accordingly it is registered. Contrary to that registrability, you cannot take a contention. Now, you have mortgaged the property.
My lord.
Yeah. Your contention is they have taken in excess of what has been mortgaged.
Over and above the security.
That is what.
We said excess, you said over and above. I said it in one word.
My lord.
Because Mahatma Gandhi says when one word is sufficient, using two is uneconomical. Therefore, that contention we cannot examine in the absence of the loan document. We will not give you time to produce that loan document because having drafted petition, filed a petition, thereafter all of a sudden waking up and starting running like PT Usha, we will not intervene in that.
In that case,
Dismiss.
I pray your lordship to withdraw this petition and I will file a I may be given a liberty.
Loni, having argued the matter at length through his counsel, seeks leave of the court to withdraw the petition with liberty to approach the lending agency with appropriate representation to work out reprieve in accordance with RBI guidelines, extant RBI guidelines. First, do you object to the withdrawal? Learned counsel appearing for the aviator lending agency graciously consents to the grant of leave. First one. Next one. In the above circumstances, leave having been accorded, petition is disposed of as having been withdrawn with liberty as sought for above. First one. All contentions are kept open.
Including Annex 8.
Whichever we do not say. Yes.
Item 4.
Challenge has made the order passed by the Central Administrative Tribunal,
Yes.
in which my MA was dismissed as not maintainable. In 4 out of 4 applications, 1 application, your lordship admitted the same and issue emergent notice to the opposite parties and grant me the entry. Similar.
Issue. Emergent notice. Learned senior panel counsel. Who appears to central government? TGC, Shri, so and so. On request accepts notice for all OPs.
No, my lord. Only 1, 2 and 3 I shall.
OP number 1, first up. Notice to
2 and 3.
2 and 3 speed post, by speed post. Any interim order is granted.
My lord, my lord.
Next one. The counsel for the petitioner draws our attention to interim order dated 19 February 2026, granted in a similar case, that is WPC number 5611 of 2026 between Sapan Kumar Khandi versus UOI and other. And therefore, therefore, the client should be granted similar benefit on the principle of verity, there being no repugnant factors. First term, we agree. First term. Next, in view of the above, application is disposed of. The interim protection granted in the cognate case of Sapan Kumar Khandi is accorded to the petitioner herein also. First one, call this matter along with WPC number so.
All the matters.
All business, yes.
Item 5.
My lord, this writ appeal is in orders.
Yeah.
Last occasion, my lord was directed to make payment on the ground of delay.
Yes.
The amount of rupees 16,460.
Yes. Have you
That-
paid?
Yes, ma'am.
Paid? Whether amount is paid?
Yes, yes.
Yes. Next. On merit, what is that?
Yes.
Sir, my lord, the impugned order
Yeah.
of the Honorable Single Judge is dated 4/3/2023, my lord. 14/3/2023, wherein it is directed to regularize the petitioner within a particular period. But fact remains, the present petitioner workman was a daily wager since 92. While he was working as such, he was on leave, unauthorized leave.
How long?
This is 13 days.
13.
13 days. Then he raised a dispute before the labor authority, and subsequently one ID case was on reference, and this was awarded that for reinstatement. That reinstatement award was challenged before this Hon'Ble Court.
Award award dated?
This is awarded 30 December 2009.
ID number?
ID number is 138 of 1998.
Yes. Whether it was a reference or he went to the court?
Reference are given, section 10 was there, then it was been adjudicated,
10.3.
then award has been passed.
10.3 reference,
Yes.
ID Act.
Yes. Then challenging the same award,
13 days absence.
yes, sir.
You were dismissed him on that grounds.
This is a kind of abandonment of service, because
Did you
on
take up that contingent?
in the
Labor court.
labor court.
Have you taken that abandonment?
Yes. So because a daily wager on the requirement he was coming and paying on daily basis. However, after passing of the award of reinstatement, there was no back wages. So this has been challenged by the management before this Hon'Ble Court, and that was affirmed.
But how intra-court appeal is maintainable?
Subsequently, my lord, another writ application has been filed by the workmen for regularization.
That order is before this.
Exactly.
They have put in 30 years. The learned single judge just
In
said,
fact, it was not 30 years. It cannot be 30 years, my lord. Because in between from the date of termination of 95, award is of 2009,
award is of reinstatement.
reinstatement, no back wages.
What is this is correct. Reinstatement gives him notional continuity of service.
And there was no such sanction post against which that workman was working.
Now because of Jago, Dharmapal.
Well, Jago Dharmapal is different. This is a workman who is working on daily wage basis as of need basis. And working
38 on need basis.
Whose need is God?
Your need or his need or your greed or I do not know. How can that?
if at all that Uma Devi judgment will the requirement.
There.
I'm conscious, man. Jago, Sripal, and the latest one is also
Bolana, latest.
But
No,
being a
another has.
No, another also has come. That's true. That's true. That's true.
One more has come.
One more has come.
Pavan.
recently.
It's
Pavan Kumar.
updated on every Friday. Jumma se Jumma tak.
So it is a pro workman after a long lapse of time. Honorable Apex Court is delivering the judgment in favor of the workman. But the factual aspect is, in fact, he was working on daily wage basis, purely workman. For that, he has taken the research to go for a reference under the idea. Then there was no question of back
There it
wages.
was reinstatement with full back wages.
No, reinstatement only.
Only reinstatement.
Yes, ma'am.
Whether any back wages are denied.
There was no award to that
No,
effect.
then
Yes, not
automatically he is entitled.
Had it been
Not
there,
in-
He is not denied. He is entitled to everything.
no, my lord, if at all there is a award and the very reference when it was been answered by the learned court below, then it should be reinstated in somewhere, reinstatement with back wages of
No.
30%, 50%. But
If
without,
it does not say anything about awarding wages, etc. Reinstatement is.
Sometimes there is a question whenever they are going to award the back wages, whether it is 40%, 50% or full, then there is a question of gainful employment or not. If at all that person
No,
work,
you should have taken the contention.
nahi, he should have adduced and elicit in the process of evidence.
That's true. The question is not that. Once a reinstatement happens, what is meant by reinstatement? The apex court said, reinstatement means everything follows. As if he was not terminated.
It has not been
Unless,
given by the learned court below.
It has not been. Therefore, I entire this one.
It is a
So
question of
continuing-
only reinstatement.
Reinstatement follows the obligation to pay full back wages and to continuity of service unless the award otherwise says. Where award says full back wages but 50% back. Full back wages with full service, or service without back wages, or 50% of back wages.
Here only,
Then this argument.
here only reinstatement is there.
Means everything has to be given to him.
No, without giving any observation so far the back wages is concerned.
But Supreme Court said not necessary.
You
No,
also
but-
bring a contrary one, which says if no award has been passed with regard to the back wages,
Yes.
amounts to denial. Bring it.
I will give the reason.
No,
Because if there is a question
no,
of
question will not arise.
Hey, this is matter for order.
Regular not
Hey, this is for orders matter.
It is for you people. And dismissed. Broadly agree with the reasoning of the learned judge.
And therein also at the threshold it has been disposed of.
Respondent has, the OP has put in more than 30 years of service.
38 years.
And that is the observation is 30 years.
It is now 38. Next.
Item 6.
When are you going that? You have to implement that any order?
Yes, ma'am.
Order of the learned judge shall be implemented within an outer limit of 3 months.
In that case, a contempt was filed. When personal appearance or directed for personal appearance, this writ appeal was filed.
Then 8 weeks.
No, my lord, let it be.
What?
3 months.
Contempt is
No, my lord, 3 months with there
We
because
have granted any time at all. Yes.
Item 6.
6 last when I took time because I go through a judgment part by honorable rendered by Honorable Justice Kumar and others. Judgment I have gone through that is a 2 pages judgment. A morning I could not. Next week
Call
only.
week of.
Item 7.
The Union of India has filed this writ application challenging the order of tribunal. During pendency of the writ application, I have filed my learned friend is filed, who is appearing for the opposite party, has filed the counter, I have filed rejoined affidavit. Subsequently, he has filed certain documents that some developments have taken place, for which last occasion I took time to file additional affidavit. Lordship may permit me to file additional affidavit today. Because this is a case, you must remember, a quarter was allotted in favor of the opposite party in the year 1995. And thereafter, in the year 1997, he married for the first time.
Why can't you tell the date? Calendar has dates also.
Oh, that three wives. No?
Four
Wives.
4 wives. Yeah.
to my learned seniors.
That is a different case, man. That is a different case.
It's a different.
That 4 wives, that is different case.
Yes, sir, tell. Thank you. We are not giving time.
March 9th March.
Yeah?
9th March.
Why date?
So what document he has filed? Nothing is there.
No, we don't agree. We are here, we are paid for conducting the cases, not for.
Then your lordship kindly see,
Yeah.
then in the year 1995.
Tell the date, otherwise we will not note it down.
Mine. Allotment order was mine on 3/11/1995 at page 65.
Allotment was made of
Allotment-
type 3/4.
By 3/4. And thereafter, my lord, he has filed a original application challenging the order of suspension, where he has admitted that marriage with the first wife taken place on 15/4/1997, man. Yes, admitted the applicant's first. No, sorry, 15/4 died. First wife was died, man.
15/4, he died.
15/4/1997, first wife Srimati Pramila Naik died. As per his declaration dated
Same case, same case. Sorry, sir. It's the same case. Yeah.
In case it is buddy.
Yes, same case.
declaration dated 21/4/97 under Annex A. Thereafter, the applicant married to Pramila Kavita Naik, and though he has,
On
that he has not mentioned, but he has mentioned that she died, but subsequently she has filed affidavit that she was alive.
She was?
Alive.
Alive.
Though the employee has declared her to have died, later
She was alive.
And what happened, man? From 90.
Second wife married on
and the date is there. Second wife,
which year?
Pramila Kavita Naik.
13/8/97, man.
13/8.
8/97.
After 4 months, or after the death. After the death.
So-called death.
So-called death.
That is for our. as
What
per
is
our
that? That's what
restrictions.
stand is of the arrest.
Yeah.
Then, my lord, what happened? And on 20. He has taken leave from 17/12/1998.
In
17/8/1997
17/12/1998
to my lord. For 2 months, she has taken leave. That is my lord.
Now what has happened, brother?
For 2 months, she has taken leave.
What was his complaint before the CAT?
Now, she has taken leave to go to his village to attend his mother marriage. And while he come back, she saw that the lady was residing in his house. She complained that she is a trespasser. She was a trespasser. Admittedly, she has filed a representation instead of filing any complaint or any FIR. Though a person was residing in his quarter,
Representation to whom?
to the authorities only. Though the lady was staying in for more than 2 months in a quarter, she used all the utensils, all the household articles of belongings to him. She said that she was a trespasser. And she has requested, but the lady also filed a report about the Mahila Commission. An inquiry was conducted by the department. The inquiry report I have annexed
What it
page
is?
51
No.
on the allegations of the petitioner.
Inquiry report dated?
That inquiry, my lord, 21st January 1999.
Saying
There, my lord, the inquiry was conducted in presence of the wife.
what it said.
It says that she is the wife and the opposite party along with his brother, children of first wife and wife, all are residing in the quarter, but on the relevant day, the wife Kavita Naik was staying there. The wife's name is Kavita Naik.
Yes.
Then we have deducted this. We have on the basis of the FIR lodged by the wife, a police case was registered. She was under
That police case is, what is the case called as? PCR. What is for India?
That Chandrasekhar PS case number.
Means
That Chandrasekhar PS case number 26 of 1999. A police case was registered.
case number?
Chandrasekhar PS case number 26 of
CS
1999.
PS case. Yes, Chandrasekharpur PS
PS
case.
case number 26 of 1999.
Repeat, PS case number
26,
26 of
99.
1999.
That was filed by the second wife.
Second one. Under
What?
section 498, 506, 34 IPC
The
and 3 and 4 of the
Cruelty,
Yes, cruelty, etc. And he was put under suspension. Challenging the suspension order, he has filed the original application before the learned tribunal. Before the
The employee was placed under suspension.
suspension.
Suspended when?
She was suspended 15/3/1999. So she has filed the original application. The original application was dismissed by the tribunal. Thereafter, we have deducted the house rent.
OA number?
OA number 53 of 2000 by judgment dated 17th April 2001. 53 of 2000.
Dismissed on?
17th April 2001.
Yes.
Thereafter, we have deducted the license fees and did not pay the house rent allowance, for which she has filed another original application challenging the deduction of house rent and the license fees. To pay the house rent allowance and challenging the deduction of license fees, he has filed the original application before the Learning Tribunal. That is my original application number 182 of 2001.
What the tribunal said?
Tribunal also dismissed the original application
On
my lord 9th February 2004.
Then what happened?
Then the opposite party filed a writ application before this honorable court, WPC number 3596 of 2004.
3596.
Right.
What happened to that?
And this was disposed of in 2023. During these years, my lord, he has filed a divorce suit against Kavita Pradhan, not Kavita.
What disposal means what? Granting relief.
Remanding the matter to the tribunal because some development has been taken place, for which directed the opposite party.
Remanding after 21 years.
21 years.
Remand dated?
Dated, my lord.
End of judges.
That is my lord. The total is there. That is my 24/8/2022. 24/8/2022.
Regular ಆಗಿದೆ. ಸರಿ. Remand dated
24/8/2022.
Yes.
And the OA was reopened. The
OA, what happened to OA?
This OA directed to pay the deducted amount.
He succeeded in that. OA allowed.
OA allowed. Against that, we have filed the present writ application.
What are the grounds? On what ground it is allowed on?
Allowed, my lord, 17/1/2023.
On what grounds? How they have structured the judgment order?
They say that since a suit was disposed of between the Kavita Pradhan and Satyananda Naik, stating that she is not the wife, that is why, since she is not the wife and she is a trespasser, that is why you pay the allowance. That is the only. But our case is that during these years, the Satyananda Naik has filed a divorce suit, my lord. Divorce suit. Yes, suit for divorce suit.
What is that? Divorce proceeding? Did you file a divorce matter or declaration? Jactitation of marriage.
Declaration, not the wife.
It's called a jactitation case.
Yes, not the. Since I have not gone through those plaints, my lord, because he has not annexed those.
That way, was it CS number or OS number?
TS 29/19.
TS number.
21.
That is so.
29 of
21/99.
29/21 of 99.
99.
Only 21.
TS number 21/99.
1990.
This is like Sheena Bora case. Very difficult to understand.
And one thing, my lord, the wife was staying is Kavita Naik and the suit was filed against Kavita Pradhan. That makes the difference.
It is another lady.
Another lady.
Ages, father's name, etc.
Father's name.
You were not party to the suit.
No.
Companies have.
Union of India is not a party. Satyananda Naik has filed the suit against Kavita Pradhan. But
Satyananda,
our
who is
case is that
Satyananda?
Kavita Naik was staying in the work.
Satyananda is your employee.
Yes,
The others, your client.
he is Satyananda. He is for Satyananda.
No.
Satyananda Naik is our employee. Satyananda Naik has filed the suit against Kavita Pradhan. And entire examination report, inquiry report, everything says that Kavita Naik was the second wife, first wife is Pramila Naik. And interestingly, the one CC also filed after the death of Pramila Naik. But
This suit was decreed on which date?
21/4/2012.
21/4/2012.
He has filed the judgment of the suit, my lord, page 34 in his counter affidavit. Here, my lord, the observation is that defendant is hereby declared is not the wife of the plaintiff.
You have taken up that contention before the tribunal.
They have taken it. They have, since they,
You did not contest that.
now we have contested. We said that, your lordship kindly see, not only the wife, the children, the brothers, everybody is reading this quarter. Our examination report clear. And Kavita Naik was staying in the quarter, not Kavita Pradhan. And after the death
Suit
of
was Kavita Pradhan.
Kavita Pradhan, ma'am.
What is his surname?
Satyananda Naik.
It was not Kavita Naik.
Our examination report shows that.
No, we want to assert that. There is some change. Kavita Pradhan, how title is structured in the suit? Kavita Pradhan, daughter of so and so, wife of so and so.
Daughter of Lakshman Pradhan.
Lakshman Pradhan. Age of
22
Kavita?
years. 22 years in this suit in the year 1999.
22 years. And Kavita Naik?
Kavita Naik, we have not checked up, ma'am. Because Kavita Naik, my lord, Kavita Naik has filed a review application.
Exam report ଅଛି. Exam report ମୋର control करतो ସେଥିରେ ଅଛି.
Let me see.
Where is that? Find out.
Kavita Naik had been staying in the said quarter with her husband, Satyananda Naik, continuously from the date of her marriage. Satyananda Naik might not have known that his wife Kavita Naik was returned from her paternal home. Sri Vijay Naik and his family residing in the said quarter along with Kavita Naik. These are the examination.
No, Mr. Bhakta, you tell us two things. One is Kavita Naik and other one is
Kavita Pradhan.
Kavita Pradhan. Daughter of what? Both of them.
Kavita Pradhan, wife of Satyananda Naik. Her father's name is Lakshman Pradhan.
That is there.
Lakshman Pradhan.
Kavita Pradhan?
Kavita Naik, Lakshman Pradhan. That is page 125.
No. Kavita Naik is also Lakshman Pradhan.
Father. Then same lady. Then identity question will not arise.
They are one person, not two.
And another thing, your lordship, he has filed a one judgment of complaint case which was filed by Pramila Kavita Naik. Pramila Kavita Naik. So, no, your lord, he has filed.
Material on record. Let us start.
No. Yes.
Pramila Kavita Naik. Pramila Kavita Naik is the
Pramila Kavita Naik, wife of Satyananda Naik.
And against Kavita Pradhan. Where my lord
Against
Kavita
Kavita
Pradhan has been
Pradhan,
convicted.
daughter of Lakshman Pradhan.
Kavita Pradhan has been convicted
But
as a house trespass.
Pramila Kavita Naik is not giving her father's name.
And
The wife, first wife.
first wife, but this complaint case was filed in the year 1999. By the time first wife died.
No, according to you, she did not die at all.
No, second wife died, but first wife died. After the death of first wife, she admits that first wife died.
No, but later you say that she was also found alive.
How could Pramila Kavita Naik filed a complaint case in the year 1999 when she died?
Have you given a charge?
How do you approve that? No, that's that. What happened to that cruelty matter?
Cruelty matter, I have not received any instruction because I could not find from the website also about the Chandrasekhar PS case number 2019 from the.
What happened to that case?
It got quashed by the Honorable Court of this Honorable Court in CRL of
FIR has been quashed.
quashed
On what ground?
on the ground of that he did not wipe the petition of
In is it that was a
LMC.
482. Was it a 482 petition?
yes sir.
Which is that petition number?
CRLMC number.
CRLMC 1893/2021
Slowly. CRL
MCL
189.
yes sir 1893
1893
please.
of
Document actually account of head office there.
it's available.
CRLMC 1893 of 2011. 11.
Allowed on?
may not be the same.
Allowed on?
Allowed on? Disposed of on?
Sir.
Given. You may not find it because the uploading was in 2014. Yes. Glad to get because yes, this I will not.
In
23 September 2011.
in Lloyd's jurisprudence, there is a reference to the English case where exemption on account of marriage was available to the couple and they took the benefit of exemption because they were a couple. Subsequently, the court on their petition held that they were not spouses. Means there was no relationship of
Between
husband and wife. On that ground, the department wanted to recover the allowances given to them. The English court denied, saying that as on the day when the allowance was granted, they themselves conducted as husband and wife. There is such a case. There is a very, in fact, Lloyd criticizes that judgment, saying that, see, if there is a dissolution of marriage, that is one thing. Marriage was there, is dissolved. If marriage is held to be no marriage, then it goes to the first day of the so-called ceremony, if at all ceremony has taken place. Courts have differentiated between these. Nullity of a marriage, which Maras Diwan on marriage and divorce, law relating to marriage and divorce, he discusses. Duncan C. Derrick also discusses this. The Diwan refers to Duncan C. Derrick. Just reflect on it. We are coming back. That is challenged here now.
But Your Lordship, we have filed a counter affidavit before the learned tribunal. I have searched for that counter affidavit. There we have next not in WPC filed by Pramila Kavita Naik, there we have stated that the CLMC was
WPC filed by?
again the Pramila Kavita Naik has filed a WPC in the year 2012.
Sir, it is impersonation. His actual name is Kavita Pradhan, the trespasser. What it is said, the petitioner is Pramila Kavita Naik, it is false. But it is true that it is Kavita Pradhan.
Kavita Pradhan and Kavita Naik.
Daughter of Lakshmana Pradhan.
So they are one and same person.
In one and same.
So where is the impersonation?
Impersonation, she said that I am the Pramila Kavita Naik, wife of the Satyendra Naik.
So what is the benefits he is getting by that?
So the service
Since
benefit,
huh?
the service benefit.
But the man is same.
Because he was staying in the quarter. The department has allowed her to stay in the quarter
How department
on the
will
ground of her. Yes, sir.
No, brother.
They have consulted board and allowed her.
Who allowed?
The department.
How department is interested
Right.
in another woman?
They board. They constituted board. I will tell when my turn will come.
May I make a detailed date chart as well as this.
No. We have heard now.
Your Lordship.
We have heard now. You articulate the points. Grounds.
Then Your Lordship kindly say CLMC, we have taken a ground that.
What is that?
CLMC.
Criminal misdemeanor.
Criminal misdemeanor.
Where it was quashed
That was
or another
quashed,
That was
cell.
a trespass matter.
but that was quashed on the ground that there is every likelihood that the petition number 8, accrued number 6, and GR case number subsection might lose its
GR
appointment.
So what it may be, particularly positive.
Quashed on the ground that OP number 8 with
That is
petition number 8.
once it was.
Petition number 8 will not get in the job in the railway once the criminal case is pending. That is why that has been what we have stated in our counter affidavit in that case. That I have gone through. Why this has been.
Where is that order?
That
Where
order
is
is
that?
that neither they have annexed nor that is available in Osman.
Do you have that order with you?
Not now.
But other day we heard you for some time. You did not keep all the papers here ready.
You are the first.
What could be this question? Question maybe on several grounds.
So that is not the issue. Issue is whether this is whether OA is maintainable or not. Whether there comes a challenge.
The way which has been challenged is maintainable or not?
Yes, sir.
That is the issue here,
Yes, sir.
according to you.
Okay, sir.
The challenge to the order passed in OA.
OA. They have a challenge. This petition is against the order of the OA 192 of 2001.
182.
Correct.
182.
182.
One.
On remand by this court.
Yes, sir.
After 20 years. Anyway, what are the grounds you articulate now?
And what now they
First ground is, you tell that. Yes, right now is the contention.
first ground ballot for a month of 2 months a person is residing in his quarter and knowing fully well that a person is residing in his quarter along with his children and family members, neither the opposite party has lodged any FIR. After return from his native village, only he has made representation to the authorities, which has been considered in the first original application by the tribunal. There they have clearly observed that neither he has filed a FIR nor the observation on being informed of the intention of the applicant through his representation to vacate the quarter, the appropriate authority. State officer also wrote a applicant to hand over the vacant person, because as per the allotment order, it is the duty of the opposite party to hand over the vacant possession of the quarter to the department.
But he says, some other lady has come in, is residing there when I was away.
But along with his brothers and children, for 2 months, 2 months he is residing beyond his knowledge. For a 1 day, 2 day, the case would have been different.
For 2 months he was on leave elsewhere. You only said, nah?
And the inquiry report shows that Lordship kindly see the
effect from 17/12/1998. He was on leave and away.
My lord. 17/12/1990.
Yes. 98.
90.
Yes.
And the inquiry report also, that is why you have conducted an inquiry report. Inquiry report states, says that in presence of the neighbors, the statement was recorded of the neighbors, the police personnel came, everybody has stated that she was the wife.
How many persons were examined there? In the inquiry, how many persons were examined on behalf of management? And who were they?
Sir, for which the petitioner has go to civil court to challenge her claim.
From the oral and written statement taken from Sri Kavita Naik, wife of Sri Satyananda Naik, the residents of Survey of India colony, who are the neighbors and closely associated with the family of Sri Naik, it is found that such and such, but
List of.
The people have to write a letter to the SPF for that if that lady will not be declared as wife of the petitioner, her eviction will be acted upon by the help of the police personnel. They wrote a letter.
Did you tell them they are strangers, you remove them with police help?
Sir, no, sir.
Police
The
has-
department said.
she has lodged a FIR report with the Mahila Commission on the basis
What
of
commission said?
Mahila Commission conduct on the basis of Mahila Commission a report was called for by the police.
What commission said?
They say that she is the wife.
Mahila Commission said that she is the wife.
The HRPC man, Mahila Commission, the Lords kindly see.
Human rights.
Human, yes.
It was challenged on the civil court.
Before that,
The Honorable High Court declared that she is not right.
But a Mahila Commission report dated?
man, police report man page 83.
Not police report.
On the basis of Mahila
What commission said?
Mahila Commission read to the Superintendent of Police Khordha Bhubaneswar grievance of Pramila Kavita Naik. Pramila Kavita Naik has reported before the commission that the husband of Sri Satyana has married such and such to Vilasini Das. Third, she again married to Vilasini Das.
Another person
Vilasini Das.
appears to be very competent person. Yeah, which commission report said what?
And the commission, your commission has directed the Superintendent of Police to submit a report. You are therefore requested to place incorrect section such and such.
That's all. What is the
HRPC has conducted a inquiry.
What is the result?
The IG of Police HRPC, they have stated Kavita Naik filed a case, reveals that after the death of first wife Pramila Naik, Satyananda married to Kavita Naik on 13/8/97 and deserted her followed by torture due to demand of dowry for which such and such PS case was filed. Accused person Satyananda Naik, Digambar Naik, Vijay Naik. They are the brothers of Satyananda Naik, Prafulla Kumar Naik, Kasinath Naik, Manoranjan Barik and Akhil Parida were arrested and brought to the court under custody. Accused persons were Sulochana Barik, such and such. So
Who is that Parida?
Parida,
He was arrested, you read it, no?
Brothers and one Barik.
Manoranjan Barik and Akhil Parida.
Akha Parida. Who is he?
That
May not be his brother because surname is different.
He's different.
that
Barik is not.
Yeah.
some of the person that
That criminal was passed.
Yes.
even if prior to that, this is the report of the Mahila Commission man, the IG of Police man. There they have stated that
The report is at what page?
page 83 man,
Go to 83.
83 of writ application. Marital status report of the Satyananda.
This is directive of IG of police. That's
IG
all.
of Police.
You are not understanding simple English. That's our problem.
Right. So
I cannot
Mahila
be more
Commission
simpler
report,
than
Mahila
this.
Commission report is not there man. Mahila Commission directed the Superintendent of Police and thereafter this report came.
Then what did the commission do in that ultimately? One case is sufficient to finish up the judges for rest of the day.
So all these facts show that from
IG's report dated?
dated my lord 7/4/2001.
Yes. Now how much money he has to pay to you?
Now, he
No, you have recovered, no?
not recovered.
You wanted to recover, that has been questioned.
House rent has not been paid and some amount has been deducted towards license fees.
How much it is?
How much we have not calculated.
No, you must have demanded, no, this amount.
Demanded that. So license fees 54,000 some as per the demand.
54,000.
Some amount, but so far other demand we have not made.
What is that 50? We should know to decide whether we should interfere or not. Quantum of money is also important to us. Suppose it is only 2,000 rupees. We will not waste so much time on that issue. But you are not telling us.
From 98 to 2000.
Whatever. What is that amount?
Amount nowhere.
Now you have taken possession of the quarters.
Yes, yes.
When did you take it?
Possession.
How you took and when did you take?
Eviction proceeding has been undertaken by state officer.
By the department.
Against whom?
By to evict Kavita Pradhan. The trespasser.
You were not a party to that.
No, sir.
She held the property how long?
Report of eviction.
She continued in that property since or 16 years. How many years?
16 years, sir.
16 years. The government property. Why she was not arrested?
The committee found that there one lady was staying in the said quarter, which was under the possession of Satyanda Naika and proceeding into unauthorized occupant of any other person residing therein. It is found that the Satyanda Naika was not residing in the said quarter. Since Sri Naika was not found present during the process of eviction, she was directed to leave the said quarter for taking possession of the same by the committee.
Where is his representative? You did not lodge any police complaint.
Sir, we have written a series of letters
to police.
The police did not take any action, hence we come to.
Which is the earliest police report you sent to the police that some lady has barged into my quarters and resided. Which is the earliest one? Show us.
Whether that lady lost the affair against the director. The lady lost the affair against the director. Director has escorted to some period.
No.
The lady.
You have made a complaint to the department only, or you also made a complaint to the police?
ଆପଣ ପୋଲିସ କି କମ୍ପ୍ଲେନ କରିଥିଲେ ତ କାଗଜଟା ଦେଖ
जो घरू गाँव आसला देखले गोटे लेडी घरे अच्छी सी इज ऑक्युपाइंग द हाउस you made a complaint only to your authority or you also made a complaint
the authority and to the police.
Which one is that?
Where is that? Start now. All right, we have understood your case. Sit down.
Then what happened in the year that shows that the first wife was Pramila Naik. Pramila Naik died on 97.
You said that, no? She Pramila Naik died on 13/8/1990. 15/4/97.
If Pramila Naik died on 15/4/97, again a complaint case was filed on 13/10/1999 by Pramila Kavita Naik against Kavita Pradhan. That he has filed a memo where Kavita Pradhan has been convicted under section 4.8 as a trespasser. This is the judgment lordship kinds.
To which how this question arose?
Because he says that.
Was it part of the record there?
No, he has filed a memo along with the written.
These things he has filed.
Yes. Lordship kindly see.
That is between the two ladies.
Between the two ladies. If Pramila Naik died in 97, how could
father?
Yeah, but he is not good.
Pramila Kavita Naik.
Who is the Pramila Kavita? Question arrested to me.
What happened to this case?
Kavita Pradhan has been convicted.
That means they are two different persons.
Two different persons.
But Pramila Naik died in 97.
No, but
we do not.
But when I was residing in the house,
Real fact.
real facts only.
You know the real fact.
Yes, sir.
Come out.
I know the real fact.
Please.
Sir, first wife actually Pramila Naik, she was paid on 15/97.
So first wife is Pramila Naik,
Sir,
not Kavita.
no.
Oh, Pramila Naik died on
Died on 15th March 97.
15 March 1997. She died.
Sir.
Okay.
Then second one was
Second.
22 November 97.
1987.
But this accused Kavita Pradhan claims that I am the second wife.
All right, because after Pramila Naik, she is the lady.
And she has filed this complaint case. For which that accused was convicted under section.
But why did she call herself as Kavita Pramila Naik?
Sir?
She is addressing her as Kavita Pramila Naik. She is not addressing her as Kavita Naik. She is addressing her as Kavita Pramila Naik.
Pramila Kavita Naik was the second wife.
It is history.
So you, both of you, we request you to settle the question paper for Oxford Law College. And all students will fail.
And Pramila Kavita Naik.
But you can find out whatever documents you have by now.
Sir,
That is I am praying for time for filing additional application.
No. We have heard,
Last time also we have heard this.
we have to decide this matter.
Madam.
Your Honor,
Even to give dictation, even to give dictation in the chamber, we have to have both of you with a cup of tea. Otherwise, we only will be mistaken in the jungle of facts.
Your Honor, in content cases, we exhibits are document for the case. Document
All
exhibit.
right, what is your case is over now? Case is over or still there are any points?
These are the only points. Let him complete, madam.
Yes, brother.
Let him place this.
What do you say?
Real fact, let him place.
Your facts, what are the facts? Do you, I will ask a few questions,
Sir.
then you can argue.
Okay, sir.
Do you, on 3/11/95, quarters was allotted to you. Brother, whether this client continues to be your client even today, there must be, because he is now with you. 3/11/95.
3/11/95 have to recall the witness.
No. 3/11/95 is the order on which you were.
No, sir. 3/11 share this for हमको.
We are putting a few facts to you.
Sir.
It is like 313 now to understand what is what. See, 3/11/95, we have. On 3/11/1995, you were allotted, your client was allotted quarters.
Yes, sir. Sir.
Correct?
Yes.
Sir.
It is a type 3 quarter.
Yes, sir.
Then on you had a wife by name. Your first wife died on 15/4/97.
15th March.
15
March 97.
15/3. When the marriage took place?
You have to listen.
First marriage is dated. You were
82 in the year
1982.
82, sir. 1980.
This is the Sheena Bora.
मात्र कोटर का चलनी हमारे कहते हैं 62 पर
You contracted second marriage.
बरे लिंक का पठन चित्र नहीं एटा तो कोलाई जेटी
42
कवरेज का पठन चित्र और 82/95 नंबर पे पठा था लिंक का तारा खोलू नहीं एटा तो मारला कोड देखो
Mr. Padu, kindly mute yourself. You are audible here.
Apart from not assisting us, you are disturbing us. Yes, sir.
sorry man
You have to change the date of the second marriage.
But
Because
he has admitted
97 now he is saying that
he has admitted before the tribunal.
that 53.
Yes.
Anyway, second marriage has taken place now, whichever date that be. And you were on leave from 17/12/98. Where you?
17/12/1980.
You were on leave.
Yes, sir.
You took leave for what purpose?
To see my ailing mother.
Ailing mother.
Mother, in the village.
Ailing mother.
Yeah. Went to
Where was she?
She was in native village.
Wait, how many kilometers?
Across the Sikrida to 125 kilometers from Bhubaneswar. Across the Sikrida, PS Nuaga, district in Nayagada.
He mastered the factor. All right. Where is your representation to the department? I'm to the police.
first representation to the department regarding the unauthorized occupation of
28 December 90.
28
December.
He returned on 26th February. Your Lordship can remember.
Sir, by
26th.
registered post, the petitioner has intimated to the department
Right.
that the sum of the trespass to my part.
Right. That is on 28/12/2019.
Note down the return date.
December 90.
Note down the return date. I just 26th February 99.
No, he's correct. There is a letter.
Yes.
On 28th, there is a letter. Absolutely.
He, on facts, he is perfect now. Yes, which was the first
I
representation?
got the service record where it.
Let us see.
We'll go back.
You gave the representation on which day? First representation given on.
Had the representative to the office 28 December 98.
After 10 months.
So 10 months. So trespass वाला 17 बार हम 10 months है ना.
No, the trespass, you returned after leave. For 2 months, you were with the mother only.
So mother fell and
Mother fell?
and he himself also fell ill.
Mother was ailing.
It was ill.
You went to see your mother
Yes, sir.
and you fell ill.
That was the petitioner, Satyendra Naik was fell ill. And he was treated in the district headquarters, Nayagada.
So he took treatment in the district headquarters.
Nayagada.
All right. How many months? How many days? He was on leave and 20 days.
First March 99.
First March 1999, he returned.
Yes, after recovery of the illness.
1990.
Yes, sir. He came to join the office, but unfortunately, he was arrested by concocted story by the department.
Wait.
Yes, sir.
May
Huh.
okay. Your Honor, please glance Annex 8 of my affidavit.
Now you are retired from service.
Yes, sir.
You retired on which day?
31st August 2014.
14.
14.
Yes.
Sir, the department has constituted a board, had a TSC number so and so. The board gave report on 13th March 99 by stating that Kavita Pradhan should be allowed to stay in the quarter till Satyendra Naik, opposite party, personally settle the issue. Annexure 1, Annexure A of my counter affidavit. Running page 158.
That is the inquiry report to last.
Inquiry report.
To settle it amicably.
Yes, sir. Then, sir, Annexure B.
8/9/1999. Letter.
Letter है DSCC order number 1 by ADM dated 14 January 99. DSCC number. The board gave report on 30 March 99. Document number 18. She may be allowed to stay in the said quarter till Sri Satyendra Naik personally settles the issue. Annex B. The department has written a letter to the Superintendent of Police stating that accordingly the finding of the board, the said lady is the second wife of Satyendra Naik. However, Satyendra Naik has filed a petition 21/99 in the Court of Civil Judge Bhubaneswar challenging the claim of the said lady that she is the second wife of Satyendra Naik. The said lady has been asking a repeated representation to the State Commission for Women, Orissa, Bhubaneswar. Under the circumstances, we are unable to take any decision regarding eviction of the said lady. Again, they say, in case she is the second wife, the Sri Satyendra Naik will be duty bound to take over the said quarter. Sri Satyendra Naik has repeatedly given us notice to permit him to vacate the said quarter. And again, the government servant has been giving repeated letters to us to accept the vacation of the said letter, but on humanitarian grounds, we have not evicted that lady out of the quarter. This letter reads to the Superintendent of Police. Then the department has inquiry a disciplinary proceeding. And the IO, sir, annexed or C. With, sir, may I say?
Yes.
Then with the help of neighbors and colonymates, I could enter into the quarter. Since then, I have been staying there. The office conducted an inquiry and collected statements of mine, my neighbors and other colonymates allowed me to stay in. Annexure D. Annexure D of this Honorable Court said that I set aside the order of lower appellate court, remanding the matter back to the trial court and directed that suit of the plaintiff be decreed with respect to his claim that the defendant is not his wife.
It was not tried.
प्रथमे 2199 बाटा हेला केस फाइल हेला सर सूट 21/99 सेटा ड्यू टू नॉन जॉइंट ऑफ पार्टी एटा रिजेक्ट हेला तार आरएफ फाइल हेला आरएफ ताको रिमांड कर तळ कोर्ट हम सेही आरएफ एग्नेस्ट ऑनरेबल कोर्ट का आसिलु एसए 10 of 2008 ऑनरेबल कोर्ट डायरेक्ट कले that I set aside the order of the lower appellate court.
What he says is, as I understand from your talk, because many Sanskrit words.
Remanded the matter back to the lower court.
Wait. You had to.
Then
the suit was dismissed.
Due to non-joint effect.
Non-joint effect.
Then
you filed appeal against that.
Yes, sir.
Appellate court set aside the dismissal order and remanded the matter for fresh consideration.
Against the order of remand, he has filed a SAO.
SAO ହେଲା पर से recall कले. Recall dismiss ହେଲା. ହେଲା पर से कले Supreme Court. Supreme Court of dismiss.
Let me. SAO order was passed. After SAO, the lady has filed a review application challenging the order of the SAO that was dismissed. Against the lady has gone to Hon'Ble Apex Court.
They also met the same fate.
Yes, sir.
That means the SAO order was confirmed, and on the basis of SAO, the suit was decreed.
And then the trespass of the said Kavita Pradhan has filed a writ petition 468/2012 on the ground by praying.
Several division bench and several single judge
To issue writ
have put their mind into the case, but they have not been able to settle it.
It is impossible to settle. This case cannot be settled.
And examination report, your lordship kindly see what the exam
It is going on. What can be?
let me
We have to guess. We have to do lot of guesswork now. What has happened? What is this? Even if
the opposite party number one, not to evict the petitioner from the
will
government.
not be in a position to process all these matters. Let alone human beings.
Since last few days also I was searching for the number of documents, but I couldn't.
Yes.
And third wife was Bilasinidas. That also I am searching for.
Yes.
Sir, only they are searching, but there is no evidence. They are fruit it is seedless, without fertilization. It is a thalamus.
Yes.
And then,
You are intelligent and humorous also. We appreciate that. But when to put an end to this case, this how many hours of judicial work might have been spent in deciding all these bunch of cases arising between you and that lady, other lady.
sir, honorable court director with
But one factor is, brother, what's his name?
Mr. Naik.
Mr. Naik.
sir.
You're also Mr. Naik.
I think
No, it happens. It happens. Mr. Naik,
Sir.
do you hear my voice? Can you hear me?
Sir.
Yes. In the criminal case that was quashment was on the ground that her career should not be marred because of the black mark. It was not on any other ground. Quashed is true. It is quashed. You said that. Whatever be the ground, it was quashed.
Sir,
True.
after decree, the case was dismissed.
No. Decree, the one more aspect.
Decree for that she is not wife of the petitioner. No, sir, 490 case decree.
Whether it was tried, was it tried and decided or by consent?
No.
No, it was tried.
Yes, sir.
How many witnesses were examined?
Sir?
How many witnesses were examined?
In 21.
In 21.
Yes.
21, sir, 9 witnesses, sir, has been examined. 9 witnesses.
Which is that judgment you have filed?
Yes, sir.
Which one is that?
Sir, annex, sir. Oh, sir.
that in Annexure G at page 34 of his counter affidavit. G. इधर तो Annexure G देखो.
The only way to write judgment is we have to call tender now. Who will be able to give us a draft judgment?
Annexure G.
Annexure G.
Sir, Annexure G, page 34.
This was passed on the basis of the direction of SAO.
Find the degree.
Not the wife of the plaintiff. The same lady. The decree said she is not the wife of, that was a Jactitation decree, saying that she claimed that she is the wife, your wife.
Okay.
Therefore, you obtained a decree saying that you are not my wife. Court agreed with that.
Yes.
So, a Jactitation decree was granted to you.
Sir.
This was not put in challenge.
No. The challenge is she the dictator hella she is Supreme Court gole Supreme Court
Against this order.
SLP
Is against SAO. He has,
That is recalling the.
so far this TSI.
Now, this order has attained finality.
no so finally
You did not implead your department, employer as the party.
Only between two.
sir Supreme
Ah.
Supreme department काय party करेगी
No, we are asking that we do not. You have married, our department has married you
This
wrongly.
is between the lady and the petitioner, whether she is white or not.
Brother, one aspect of
Department
it.
has no role in this case.
Brother, CGC, one point arises. It's a matrimonial decree. The decrees granted in matrimonial jurisdiction are decrees in rem. That's what we have been taught in the law school. Section 41, 42, 43 of the Evidence Act. Therefore, whether you are a party or not, you are bound by the decree. Yes. Decree says the lady who had trespassed is not his wife. If that is so, how can we recover that money from this poor person?
But this decree was passed in the year 2012, man.
Anyway, if it is not a divorce decree, it is a declaration of, and a declaration that it is not even nullity of marriage. It is a Jactitation decree in foreign law, right on marriage and divorce. Here says, this is a decree of Jactitation. It is not a nullity of marriage. Whether a Jactitation decree also operates as a rem? If it relates to marriage,
It has to be in matrimonial.
it will be matrimonial. Whether order of the decree of Jactitation, how courts have treated the. If the court has said, she is not the wife, A is not the wife of B, or B is not the wife of A, A being the respondent here, would be here.
But prior to that, in the year 1999,
Mr. Dr. Chudi, do you have any idea about the Jactitation decree? No. Whether it operates as a Jactitation decree, saying that B is not the wife of B, A. Defendant is not the wife of plaintiff. Whether that operates as decree in rem or not, that is the question. If it is said nullity of marriage, etc., we can understand. Jactitation decree can be granted by ordinary courts also, whereas matrimonial decrees can be granted only by the matrimonial courts. Whether you have matrimonial courts in the state, we have matrimonial. Family courts are matrimonial. It's not a decree of family court. It's a decree of city civil court.
Then the family court was not there. And so all the civil justice senior division had deemed
Your Honor, Annexure K.
Yes.
Annexure K, page 680, this Honorable Court says, moreover, at the present juncture, the petitioner cannot describe herself as the wife in view of order passed of this court on 3/12/2010 in SAO 10 of 2008 and order dated 24 February 2014 passed in SLP 18064 186 of 2013. Order dated.
The law is heavily loaded against you, but justice is loaded in your favor. But law is completely against you.
but your lordship kindly see the examination report, just 2 paragraphs I am.
No, thereafter court decree. That report is prior to the decree.
My lordship kindly see the.
Your Honor, it is arbitrary they have done. They have no power to declare or to issue whether one is white or other. It is the court.
Lordship kindly see the examination.
So what
report
he says appears to be sensible.
Sensible, true. Lordship kindly see the examination report. That is also sensible. Lordship kindly.
No, that is prior to the decree. Once decree is passed, but everything pales into insignificance.
But Lordship kindly see 2 paragraph. From the written statement, it is also established that the lady Srimati Kavita Naik had to stay on the veranda of the said quarter in hunger and morning hard till evening when Sri Prafulla Naik, brother of the opposite party, reached her with the information that the key of the locked quarter was also not available with him and was available with his brother Sri Vijay Naik. That the lady contacted Sri Vijay Naik on his Kotak telephone, but it was in vain. On 17/12/1998, in the evening, Srimati Kavita Naik, finding Sri Prafulla Naik roaming in the colony, called him to open the lock of the said quarter. The lock was broken by Sri Prafulla Naik. That means,
so what we are saying is, now there is, when he said she is not my wife,
That's all.
When she said if she is not my wife, you would have thrown her out from the quarters.
Would have gone for eviction immediately.
Immediately.
But you can't take
The
it.
lady has filed different cases against the department also.
What
Might
we do? You should have you should have taken the possession of the property immediately by going by ST.
Our allotment letter shows that he has to given back and possession.
Correct, but he says, I am a poor employee, I went to see my ailing mother 110 kilometers away, and I suffered a fall,
And for a,
I was admitted to hospital. That is his case.
but his
Appears to be,
But the
he
law-
appears to be victim of so many circumstances.
but the lock and key, everything is available with his brother.
Straightway you should have gone, thrown them out, saying that brother is not the employee. And your brother is saying that you are all trespassers. Therefore, we are throwing you out.
Department has not evicted anybody.
Then why he should pay for
Due to the
occupation
different
of.
cases filed by the lady,
This is the process. They have done.
Why his client should
and
suffer?
after only retirement, we have evicted.
You should have done it long ago.
And he used everything.
You
The
are-
household articles, he used everything. The household
Has
articles.
said to the department that the quarter has been surrendered and you take the possession. But they did not take.
When you told that?
When did you say this?
When did you tell that? You are very angry on your friend. You must be angry on him.
No, sir.
He is arguing his case, you are arguing yours.
No, sir.
At the most, you can be angry on us. But when did you tell them to take the possession of the property?
When did you surrender it?
Which date?
Sir, they have not the possession.
Right now you said that I have,
Sir, we have retained the department, please give our property, but they say, if you give 54,000, then you will take you will be permitted to take your property.
No.
They did not take the property.
1 second. Just look at me
Sir,
with a smile.
okay.
Now, when did you tell the department, those who are in the occupation of my quarters are intruders, trespassers? On which date you said that?
On 28 December 98.
28/12/98.
28 December 98. We have intimated the department.
28/12.
28 December.
yes.
No, it cannot be. 17/12/98 you went on leave.
So 1780 the trespass.
You went on leave on 17/12/1998 for 2 months.
Okay, sir.
Not okay.
That's what the records say.
Sir.
It's correct.
When did you move on leave? What is that date?
On 13th December, 13th December 98.
That is what. So, it is only after you returned you saw that your house is under trespass.
You returned on which date?
Return on 1st March 99.
1/3/1999. Yes.
1/3/99. Then how could you make a representation on 28/12/1998?
That his brother, the petition's brother, and told that someone was breaking the door lock.
Show that. Where is that material? Show that.
No. সেটি দেখি নাই স্যার এই আমার 443 কেস এর এপ্রোচে আছে এই যে কমপ্লেইন কেস আছে সেই কমপ্লেইন কেস তো লেখা আছে
No, you told the department.
স্যার
You told the department that some other persons have occupied trespassed my house
ওকে
and they have taken possession. Therefore, you take action against them. When did you tell that?
on 28 December.
Where is that material?
Where is that letter?
ওকে স্যার কোয়ার্টার কিছু ফাইল হয়েছে ও কোন সার্টিফিকেট
You are the lawyer for him throughout in all cases, or only in this case? Are you his lawyer in this case alone or in other cases also?
স্যার
You are the lawyer for him in all throughout.
ওকে স্যার
Not okay. Okay means, are you the lawyer for?
Yes.
He says yes. For yes, he says uses the word okay. Now, where is that letter? Show us on 28/12 you informed them about the barging of house by the others, that lady and your brothers, etc. That will be clinching evidence.
Two judgments are there regarding this decree.
Yes.
One is Mir Fazlat Ali versus Mohammed Unisa.
Is it from Allahabad?
Equivalent citation is 1819 ILR 20 96. This is the
On Jactitation decree.
man. And another is
1 second, we have not noted. Kindly tell the citation.
this is 1898
1898
ILR
ILR
20
20
ALL
huh?
ALL.
Allahabad.
Allahabad.
96. 96.
90.
Another Privy Council judgment is Raja Nilamani Singh
Raja Nilamani Singh
versus Kali Charan Bhattacharjee, 1874, 12, PRI.
1874 QEQ.
No, my lord, PRI.
PR.
PRI.
PRI.
CK.
CK.
CK. 0001.
0001.
Mine. These two judgments discusses about this decree.
Jactitation decree. What they say? Do they say Jactitation decree operates as a decree in rem?
Yeah, not specifically specified, but it's, the language is like this.
That it use that.
Yes.
In some paragraph you have.
Yes.
Just read that. Just read.
This is. Now, Privy Council decision Raja Nilamani Singh.
Yes.
This was a suit instituted by the Raja Dixit against a great number of his royals, about 52 in his own language, obtained possession of 10 wrecks. That would be the better something. This Mir Azmat Ali.
Now, what the point in what is decided? The tough cases make hard cases make tough law. There is one way.
This is a suit for Jactitation of marriage, which was brought by a Mohammedan named Mir Azmat Ali.
So,
The operating person is this was quoted by Raja Nilamani. The first appellate court dismissed the appeal on the ground that such a case came within the ruling of the Privy Council in Raja Nilamani Singh versus Kalicharan Bhattacharjee.
So in 1898. Yes.
And consequently, the suit didn't lie. But the case before the Privy Council was a very different one. The decision apparently is one which would forbid the institution of a novel description of suit to set aside a mere assertion. A suit for Jactitation of marriage is not by any means a novel description of suit. It was a suit in which relief was given in England in the
Celestial.
And when the jurisdiction of those courts was transferred to the divorce court by the Act of 1857, the jurisdiction of the ecclesiastical courts in suits for Jactitation of marriage was transferred to the divorce court. In England, it was not only a well-known suit within the jurisdiction of the ecclesiastical courts, but it was considered proper that the jurisdiction should be continued by the divorce court in England. And there can be no doubt that unless a man is entitled by means of the civil courts to silence a woman who falsely claims to be his wife, the man and others may suffer considerable hardship, and his heirs may be harassed by false claims after his death. The suit for Jactitation, however, is one not to be encouraged, particularly in a country like this, in which persons unfortunately are too anxious to discover forms of legal procedure by which they can annoy their neighbors. In your opinion, our such a suit lies in a civil court in this country, the court trying such a suit will of course take care before granting a plaintiff a decree to see that it is strictly proved that the defendant did seriously allege that the disputed marriage had taken place and that the plaintiff didn't acquiesce in the claim or allegation of the defendant as to the disputed marriage. And further that in fact no marriage had taken place between the parties. We set aside the decree of the lower appellate court and remand the case under section 562 of the Code of Civil Procedure to that court to be disposed upon the merits. This is the.
But if it does not indicate that it is a it's a rem personal.
Millard, in the Google, it is saying that the judgment in rem affect the status of the things, the marriage status binding on everyone. It is judgment in rem as Google suggests.
Correct.
Summary and the legal effects. Particularly keeping in view this judgment.
This judgment is also referred in that.
Yes.
Then it makes your case still worse.
Your Honor, in a petition 3596,
Yes, we have understood the case now. Okay.
the undisputed fact,
Okay.
as emerged from the record available for this court, is that one Kavita Pradhan had occupied the quarter in question, which was allotted in favor of the petitioner. The petitioner claims that Kavita Pradhan is not his wife, and as such, he is not liable to pay the house rent and electricity charges for the said quarter. These facts are now brought to the notice of this court. We are not placed before the tribunal while passing the final order. Therefore, this court is of a considered view that if by virtue of a civil court decree, Kavita Pradhan has been declared as not the wife of the petitioner, she should have been declared as a trespasser to the quarters allotted in favor of the petitioner. Therefore, for an unauthorized occupation of the quarter by Kavita Pradhan, who is a trespasser, the petitioner is not liable to pay the house rent as well as the electricity charges, which have been forcibly deducted
All right.
from the authority from salary of
You are
the.
reading from CAT order.
Yes, sir, order.
CAT order. That appears to be.
But he has not filed any document of.
What's wrong? It's a decree of the court.
That is there, no?
Basis of decree, my lord.
What can we do? We know that the government suffers some financial loss, but what to do? It suffers because the principles of law correctly not applied, and so many things have happened.
Had it been she has been evicted.
Yeah, you should have gone. You should have called the police and taken use of the
But he
police
has
to
filed-
remove them.
Whoever gone, she has filed cases against them.
Well, therefore, what he should do? She had filed case against him also. What can be done? Well, if, we do not know if she will file cases against us also. But anyway, no, we cannot be timid. This is the petition. Take it off. Sit down now. The facts of this case are stranger than fiction. First one, the Union government and its officials having suffered an adverse order at the hands of the Central Administrative Tribunal, Cuttack, in which Cuttack entered in OP's OA number 260/00182 of 2001, are knocking at the doors of Writ Court. First one. Next one. Learned CGC appearing for the petitioners submits that once an official quarters is handed to an employee like the OP, it is his bounden duty to pay for that or to suffer deduction of rental allowances, stroke license fees from his payables. as long as he remains in the immediate occupation thereof or mediate occupation because he allows or deemed to have allowed others to make use of the said quarters. First one, the tribunal, in not approaching the matter with this view, has fell in a grave error of jurisdiction, and therefore the interference of this court is eminently warranted. First one, he takes us to the pages of petition book and also the documents filed by either side, which would reflect a host of facts which may not be much relevant for our consideration. First, learned counsel representing the OP vehemently opposes the petition, making submission in justification of the impugned order, mainly contending that in a matrimonial proceeding, he has secured a degree of Jactitation of marriage, and that would operate as a judgment in rem, and therefore res judicates the petitioners from contending to the contrary. First one, he tells us that once such a decree is obtained, the persons who had obtained, the judgment debtor who had obtained occupation of the property, who had occupied the property or the quarters in question, has to be treated as a trespasser, and therefore there is no liability on his client to make any payment for the occupation of the trespasser, against whom no action was taken by the petitioner, despite intimation on 28/12/1998 to that effect. First one, he also turns several pages of the record and presses into service certain facts which we would advert to in due course. First one. Next one, having heard learned counsel for the parties and having perused the petition papers, we decline indulgence in the matter for the following reasons. Number one, the allotment of quarters in favor of the quarters of type 3 was made in favor of the OP, while the allotment letter dated 3/11/1995. First off, the OP, on being sanctioned leave for 2 months, was away from the quarters with effect from 13/12/1998 to see his ailing mother at a place said to be at a distance of about 110 kilometers. First off. When he went there, as the luck would have, he suffered a fall and was admitted and was hospitalized for treatment. First time. On coming to know of purging of the said property by a particular lady and others, quarters, not property, quarter, an intimation was sent to the petitioners to take action against them. First time. There were certain cases and counter cases between the OP and the alleged trespassers of the quarters. First one. A complete detail of that may not be required for the adjudication of this case. First one. Suffice it to say that the OP in which is that case Jactitation decree. Now the decree of nullity is so
21.
No, not that. Your case.
Our case is 21. Yes.
Titles of 20.
TS account
In CS number 21 of
99.
1999 has obtained after full-fledged trial a decree for Jactitation of marriage on
26/4.
26/4
26/4/2012.
26/4/2012. To the effect that the occupant of the subject official quarters was not his wife. First. Next slide.
21.
Sorry, 21 April.
21 April 2012.
26.
21/4. Next slide. In Indian judicial system, judgments in rem are rendered in 4 jurisdictions. 1, matrimonial, small Roman. Roman 2, admiralty, 3, probate, and small 4, insolvency. First, this is how Withdrawal and Amirali in their Evidence Act, in the commentary on Evidence Act, more particularly sections 41, 42, and 43 of the Evidence Act deal with the matter. First one. There is some reference to Jactitation proceedings in a very old decision of Allahabad High Court in ILR 1898 ILR volume 20 Allahabad 96 between so and so. First time. There is also a reference by the Privy Council about an Indian case which treated to an extent about the decree of Jactitation obtained from a court on Indian soil. That is 1874 PRI CK 001. First term. There is not much support to the view as to whether such a decree would operate as a decree in rem. Is also true. Is also true. First term. We are told at the bar that the Jactitation decree in question has been granted by the civil court in as much as during the relevant period the civil courts were exercising the family court jurisdiction. First term. Matrimonial jurisdiction. Matrimonial jurisdiction. Till the family courts were established. First term. Therefore, we have more justification to brand this decree as a decree in rem. First term. Decrees of the kind would operate for world at large. First term. At least such decrees or such decrees res judicate those who were not parties to the proceedings from contending anything to the contrary. First term. Therefore, learned counsel appearing for the OP is more than justified in telling us that the liability for the occupation of judgment debtor in Jactitation decree cannot be fastened on his client. First. In the next paragraph, a perusal of the record of this case shows that the judgment debtor had approached Women's Commission. What do you call it? Women's Commission?
HRPC.
Mahila Commission in HRPC. Which is that case, the registration of case. So and so, afterwards collecting. So and so. And there was a report by the Inspector General and Director General of Police as to the alleged, as to the said judgment debtor and the OP having projected themselves as the couple. First term. However, all that would first. Learned CGC also brought to our notice the inquiry report dated 21/1/1999, correct?
Well, 21/1/1999.
1999 to the almost to the same effect. First, the report also mentions about brothers of the OP having resided with the JDR in the official quarters. First time. However, all that would be subsumed into the decree in rem, comma, there being no further challenge thereto. First one. So many proceedings and cases which both the sides have mentioned, taking us through the record, do not merit a deeper examination in view of the Jactitation decree. First. Next paragraph. The impugned order has been structured by the tribunal in its accumulated wisdom as a statutory body constituted under the provisions of the Administrative Tribunals Act 1985 and its powers and limitations have been delineated by the Apex Court in SP Sampath Kumar versus Union of India, AR 1987 SC, and L. Chandra Kumar versus Union of India, 1997, so and so. First one. In the light of that discussion, this court exercises a limited supervisory jurisdiction under Article 227 of the Constitution of India in the light of Mirajkar versus State of Maharashtra. In that judgment, take out that. Versus State of State, that two people. First one. Therefore, this court cannot undertake a deeper, say Naresh Sridhar Mirajkar versus State of Maharashtra, AR 1967, SC, page 1. First. Therefore, this court does not exercise appellate, cannot sit in appeal over the orders of the tribunal passed in the admitted jurisdiction. Notwithstanding employment of ornamental employment of Article 226 in the pleadings of the petitioners. First, in the above circumstances, this petition being devoid of merits fails. First, it is open to the petitioners to proceed against the occupants of the quarters in question for recovering the damages or the loan elsewhere in accordance with law. First, it hardly needs to be stated that the run of the proceedings that ultimately resulted into this judgment would be a ground for exclusion of the period spent during their pendency under Section 14 of the Limitation Act 1963. Now we have saved the limitation period also against them. All right, you can make best of it. Of course, in that connection, all contentions are kept open. Both your
in
assistant.
a lighter way, my lord, a person get justice because of his conduct. Last 27 years he is suffering.
May I submit? May I submit?
I'll get the hand of that lady also.
May I submit, my lord?
Conspiracy of circumstances make us victim. That's the reason why that P.B. Shelley, in that famous poem, I forgot the title of that poem, said, I fall on the thorns of life, I bleed. We only fall on the thorns of life. Sometimes on the flowers also. That would equally pierce.
The appointment is a season and
judgment. Item number 9, sub-item 2.
Item 9.2.
2.
Huh.
Both the matters are tagged together. Actually, second matter, my matter is not
Different
same
matter.
as the first one.
Detail. Serial number 2, item number 2, WPC 24349 of 2025 to be detailed. Okay.
Taken up some other.
Call up 3 weeks. Yes.
Special notice.
Huh.
Special notice item 1.
Yeah.
But at this time, there is some defect in the ODI translated coding. My lord, this review has been filed against the judgment passed by this honorable court on 10 to 2026, my lord. On February 10, 2026, my lord. In the read petition, my lord, the review petitioner was impleaded as opposite party number 1, my lord, in the read petition. He is the review petitioner before your lordship, my lord. Then
OP number 2.
OP number 1, my lord.
1.
My lord. OP number 1 in the read petition is the review petitioner.
Who is the lending agency?
Lending agency, Bank of Baroda, my lord.
Bank of-
Opposite party number 3 and 4, my lord. Sorry, 2 and 3 in the read petition.
Yeah.
My lord, what has happened, my lord? Here the review petitioner, who is the opposite party number 1, availed, my lord, 2 loans, my lord. My lord, very essential to mention this. There are 2 loans availed from opposite party number 2 and 3, my lord. One is relating to Judicial traders and another one is relating to Judicial enterprises. The loan was taken on 10/8/2011. For Judicial traders, the enterprises, the loan was for cash credit and it was for 20 lakhs, my lord.
Why were you not before this court?
My lord, I
Despite
have-
service of notice.
My lord, I have explained, my lord.
What is that explain?
My lord, I have explained, my lord. The opposite party, after receipt of the notice from this honorable court, my lord, handed over the brief to my lord, one of our advocate of this honorable court, Sri Saroj Kanta Satpathy, my lord. My lord, he assured to appear before this honorable court on behalf of the and receive the Wakalatnama. But he could not appear before this honorable court because he suddenly detected with a cancer and he was, after prolonged, my lord, treatment, he died, my lord. And it was not within the knowledge of this opposite party. After passing of the judgment of this honorable court, my lord, immediately the bank served the notice on the opposite party. From he came to know, and after ascertaining the fact, he came to know that the late Satpathy could not file the Wakalatnama because of his illness, my lord. And the bank has suppressed the fact that the account was, both the loan accounts were closed.
You had made payment.
Yes, my lord.
When you had made payment.
My lord, may kindly have a glance too. My lord, there are 2 documents to show my bona fide, my lord. Your lordship may kindly have a glance to page 16. Your lordship may kindly see page 16 of the review application, my lord. It is issued by the bank to Sabita Judicial traders. My lord, may kindly second paragraph. We have calculated the balance amount payable by you to the bank and this comes to nil. I have paid.
When did you pay?
My lord, prior to this.
How much you paid?
My lord, total I have paid 73,50,000
By bank?
to the bank.
Check.
My lord, it was in shape of demand draft and demand draft, my lord. It has been observed by when essay was closed by the Debt Recovery Tribunal, it has been observed. It is there, my lord. My lord, may kindly have a glance to page 29, the essay which was challenged of the prior auction notice before the Debt Recovery Tribunal. After that order, that letter was issued.
Thereafter, you have made the payment.
Yes, my lord. My lord, may kindly see. Page 29. In the meantime, page 29, the order of the essay,
Yes.
judgment of the essay,
Operating part.
and it was, my lord, may kindly have a glance.
Printer deposited 73 lakh 50,000.
50,000, and the applicant is in possession of the property, and the respondent bank returned the amount of rupees 85 lakhs 93,500 to the auction purchaser, and the loan amount is fully satisfied after deposit, my lord. So, my lord, therefore, my lord, what has happened? The DRT, while passing the order, has observed one line, my lord, page 30, my lord. May kindly see. He has observed that there is some outstanding. The bank can proceed for recovery with due process of law. Thereafter, my lord, after this order, they have issued the sale notice, which I have given.
There is any amount is due, the bank is liberty to take.
My lord. My lord, in fact, my lord, may kindly see annexure 4, my lord. At page 33, I have passed over, my lord, the translated copy. It is, the notice was, sale notice says, it was the demand which was prior to, my lord, disposal of the essay. And the sale was conducted. Therefore, my lord, I have immediately rushed to this honorable court. And this honorable court protected me. I have also annexed that order.
Where is that?
My lord.
Your DRT order was on 28/7/2018.
Yes, my lord.
And this notice was on 7/8/2018.
After that, my lord, this observation, after this observation of the DRT, they have given sale notice. For claiming that amount, your lordship may kindly see what is the amount claimed.
Since he did not come.
74, my lord, 30 lakh 69,000 is again, my lord, they have demanded. I have said that I have paid the entire amount. How could you demand this amount?
That notice
So,
was to,
that, my lord,
was to Sabita Jaiswal Trader.
my lord.
Now it is Jaiswal Enterprise.
Now, both, my lord. My lord, may kindly see essay. Essay was in respect of Judicial Enterprises. Essay order was passed in respect of Judicial Enterprises.
Are there two entities actually?
There are two different entities. One for
Whether these entities had separate loans?
yes, my lord, separate loan.
But who is the proprietors of this?
My lord, in
Who are the
Judicial,
proprietors of these
my lord,
entities?
in Judicial Trader, Sabita Judicial is the proprietor.
Proprietaries.
Proprietor.
Then another one.
In Judicial Enterprises, Sandeep Judicial is the proprietor. Both are mother and son.
Mother and son.
Mother and son. My lord, they have paid, my lord. What has happened, my lord?
You take notice. There appears to be some. This happened because you did not come before the court.
My lord, that is, my lord, it is a mistake on the part of the opposite party. And the DRT condoned the delay, taking into account the pendency of the writ petition before this honorable court, annexure 6, in which stay was granted. Later on said that since there is a disputed question of fact, this writ petition is not maintainable. And
what is the extra amount, whatever amount is remaining due?
my lord, as per the sale notice, it was 36 lakhs, but as per their notice, it is 27 lakhs.
27 lakhs.
27 lakhs.
You pay 27 lakhs.
I'll deposit, my lord, 10 lakhs. My lord, 10 lakhs I'll deposit. Within 3 weeks, I'll deposit.
Not 3 weeks. Within 3
My
days
lord,
you have to deposit.
my lord,
Otherwise you are not.
my lord,
Yes, that
10 lakhs is a big amount.
that is big amount means you have taken big amount, it has become bigger. What can we do?
My lord.
Arithmetic operates that way. Heard learned counsel appearing for the review petitioner.
Review petitioner.
Review petitioner. First up, he took us through the DRT order.
DRT order.
DRT order
70 of 2017.
made in SA 70 of 2017,
17.
which contains certain observations to the broad effect that the entire loan amount has been repaid, and that whatever little remains as a residue, comma, the bank can take recovery proceedings. First, here you are dated.
My lord, dated, it is 18, my lord, 2018. 21/7/2018.
Sorry. First off, he also tells us the circumstances that resulted into passing of our order. Ex parte his glad. First off. Now that the auction is scheduled to be held on.
The auction already conducted. We are taking physical possession by virtue order of this honorable court.
Auction having been held on.
My lord, it was long back, 2018, my lord. It was held on 6/9/2018.
6/9/2018, comma. No, it's not. Now here. Now the possession of the property furnished by of security for repayment is being sought to be taken by the auction buyer. And therefore, he says, he seeks interim protection. First of all, a prima facie case is made out for granting interim protection in terms of IA number so and so supported by ability.
99/26.
Next, in the above circumstances, subject application having been favored, this court directs the parties to maintain status quo as to the possession of the security property concerning the subject loans till next date of hearing, subject to review petitioner depositing a sum of ₹10 lakhs with the respondent OP Bank.
Before the registry.
Why registry?
It is a disputed amount, my lord.
We'll tell them
Let it
the
be-
bank is a Union Bank of India, nationalized bank it is.
Yes.
Why we should do all that headache?
Kept in a separate account, my lord.
That
Interest bearing account.
what you say? 10 lakh in 2 equalized weekly installments with the respondent bank, which shall hold it in an escrow account. Escrow account, subject to outcome of the petition. First, if deposit is not made accordingly, not only interim order stands rescinded on its own, but petition runs the risk of dismissal as well. First. Next point. Since we have made this interim order ex parte, the opposite parties, what you call in review petition? Respondent,
Review petitioner and respondent.
the office, it is open to them to seek variation or rescinding of this order if grounds do exist therefore. Then it will be immediate.
My lord,
Depend
my lord.
interim order to be handed. Copy of the interim order to be handed to the counsel for the petitioner who undertakes to address the official office requirement within a reasonable time.
My lord, notice by speed post.
Yes, issue number 3 below that is.
Or lordship may issue by special peon, special messenger also. Cut us down, my lord.
Usual steps. It is open to the petitioner to take hand summons to the office. This is in addition to taking usual steps.
DPO.
All this happened because you did.
My lord, because of my latches, my lord.
Supplementary list item 8.
My lord.
Directed the concerned official to file an affidavit with regard to payment of the financial benefits and to the exact cost of promotion that.
Service benefits because of that Mohanlal judgment.
Actually,
as well as
The promotional.
promotional. Where is that affidavit?
My lord, the consular officer is sick, my lord. Actually, he was suffering from cardiac issues, and yesterday he was also feeling sick. My lord, he sent me an mail and requested for 1 week adjournment.
Yesterday he was here.
My lord, he was here. He was saying that he was discharged from hospital before 1 week, my lord, and yesterday he was also feeling sick. But today morning he, my lord,
Call this matter on 10/3 for filing of the affidavit, filing which some action may follow, some punitive action may follow against the official consent in view of breach of undertaking. Yes, we'll take action. If on 10th he should come and show you the affidavit. Otherwise,
May I pray, may I pray, my lord? May I pray? Lordship may indicate any other, suppose he is ill, any other officer can also.
the affidavit, we make it clear that any responsible officials also can swear to.
Yes, he is not the only officer in this.
Next.
Item 9. May I please, Lords? Order upon Lord and Tom.
Last time your lordship directed me to take instruction. Just 2 days before I got instruction, written instruction. I need 2 weeks time to file counter.
Counter is not required, my lord. The file counter is a cover matter. Your lordship already had the matter last time. And last time the mention was made that it is similar case has been that it is connected, but it is not same to this case.
7 days time at least may be granted to me so that this officer concern is coming. I will have
It is a cover matter.
If it is covered, he will not give time.
Your lordship may kindly see
No
this.
section of file.
This same bench allowed the case, but in my case, that is one part allowed, another part that your lordship already had. There is a special pay and
We
a
will say
special.
that you sought for time, we rejected it. We'll say in the order, so that will protect you.
And I will show to your lordship there an aberment from.
This official concern is coming today. 7 days, 2 days time may be granted so that it can set up.
Yes. Yes, so to be quite, what you cannot reply.
He's saying that a
Counter affidavit.
They have already filed counter that is in your record.
Instructions also required. 2 days time may be granted. He is coming today.
Call this matter next week at the request of the CGC. Come up finally.
Here, Lordship, the other matter tagged together. Because under a misconception, it is tagged together. That may be released and it can be.
That has already been released.
Yes, we have done that. Somebody came and council came and done that. Yes.
Let's see, one more page, may I pay one page? The correcting matter, one additional letter of file on 17th of February. This one. That is not available in the record as per the policy. 17th of February.
Registry to post the WP along with the affidavit said to have been filed on
17th of February.
17th of February.
Item 10.
This is the matter that where the trade union having largest number of workmen in the coal bearing area. A trade union having largest number of workmen in the coal bearing area. They have been restrained from participating all statutory, non-statutory committees. The statutory committees, mines could say, Lordship knows, then non-statutory committees, there are safety committee.
Are they recognized
registered trade? And they have been doing
registered and recognized. Registered is different.
The recognition process they in the industry, in the employer, they have not yet done for any union. That's a statutory obligation. They should have done in terms of 94 rules. And also on the chapter 7 of the
registration is under 1926.
Trade
Indian Trade Union Act.
Trade Unions Act 1926. The recognition is under which provision of law?
Under recognition of trade union rules 1994. That rule, in fact, immediately I am not having it. But if a lordship sees,
rules are there.
94.
We understand only
that rules, Odisha rules.
Odisha rules.
In the local law, it will be there. 94 rules.
What they say?
That rule says that for the purpose of recognizing a trade union with regard to the negotiation with the management, my lords are aware. They will have
legal positions were strict. Only recognized union or that, but and suppose no union is recognized. Just make a cursory reference to your Orissa rules. I am not much conversant with I am not conversant with those rules because I am not
Must
seen
be
them.
conversant in the corresponding rules in the Lordship state. That must be there. Everywhere it is there. Everywhere. Lordship will not recollect.
On the labor side.
But pending that, can I continue with my submission? That they will find it out.
Yes.
But in fact, this is the union. I have given the oldest union, having largest number of workers. In fact,
How to know that you are the largest?
But we have
You are
said
the
that.
largest.
We have said that on affidavit, madam.
The Deputy Labor Commissioner.
And they are in fact affiliated to INTUC Delhi. But let me just take a little history here. INTUC Delhi. Now INTUC is the parent union. There was a difference intra-union dispute.
Indian Trade Union Congress.
Yes. There is an intra-trade union dispute with the Reddy group and another group. But for the purpose of JBCC 9, there was a suit filed in Delhi High Court. Am I clear, my lord? JBCC 9, there was a civil suit filed in Delhi High Court. If your lordship would kindly turn to page 8 of my writ petition. Kindly see page 8 of my writ petition. The ordering person is at page 12. My lord, would your lordship kindly turn to page 12?
No, you are to be called to that meeting. On what basis? Where is your right to be called?
Yes, coach.
Kindly show that.
Kindly see, lord. We have filed that relevant rules before your lordship, my lord. That is page 101. Then I'll take your lordship to the Industrial Disputes Act, relevant chapter rules and other things.
101.
Right, Lord. Of my running writ petition, I have given the relevant portion of the rules.
Which rule gives you?
Lord, this is 29Q.
29Q. Go to 29Q. Q. Not Q.
Q, capital Q. That you got from my brief. If there, I have an extra.
Yes. To some extent, rules are uglified, but anyway.
Then your lordship would kindly see Industrial Disputes Act, madam.
No, we are to see this one.
That this rule.
Just face this rule.
Right. For every mines wherein 500 or more persons are ordinarily employed, the owner, agent, or manager shall designate 3 suitably qualified employees of the mine in consultation with the registered trade union in the mine. And where there are more than one registered trade union, the union recognized as per the procedure in practice or more representative union as per the membership records available at that point of time. And if there are no registered trade union, in consultation with the elected representative of the workmen as technical experts to carry out inspections of the mine on behalf of the workers employed therein. One each of mining operator, electrical installations, mechanical installations. When the number of persons employed in a mine exceeds 1,500, the workman's inspector shall be assisted by one additional workman inspector in mining discipline for every additional 1,000 persons a part thereof. So what I'm trying to tell here is the workman has a role in respect of this safety committee, which is to be formed by the employer, depending on the number. Then there are 2 things you are getting. One is a registered trade union. Other is a recognized trade union.
No, where is your right to be called to the meeting?
But this committee, they will take the workmen.
No.
They will take for the purpose of the safety committee.
What this 29Q says according to?
Well, let me read it again.
Read.
For every mines wherein 500 or more persons are ordinarily employed, the owner, agent, or manager shall designate 3 suitably qualified employees.
That's how.
Right, Lord. Employees of the mine in consultation with the registered trade union. There my right comes.
For what? Your right to be consulted.
Yes, Lord. That
is not right to be called to the meeting.
No, consulted trade union. They have stopped it.
Huh?
They have completely stopped me from everything. That is the point.
Now, what is happening now?
But now, if your lordship would kindly see Annexure 1, the order they have passed here.
Saying
that we will not be allowed to participate in any meeting
Where is your right to be called right to participate in the meeting?
Kindly see Annex 1, my lord. Unless our workmen are nominated through a registered trade union, there is no question of any meeting.
No, why for that meeting? What law says,
yes,
your members of the union can be union to be consulted while appointing or designating your three persons.
Yes.
When is right to participate in the meeting? Which meeting it is?
Lord, participation in the meeting, Lord, that for the purpose of maintaining amity and relationship.
Where is that right to it?
Lord, that is there, Lord. Kindly see, Lord.
Yes. How this rule is interpreted by various judges of this court?
Kindly see, my lord. Again, in the Industrial Disputes Act.
No, 1 second.
Is there
your submission on rule is over now.
Yes, madam.
We are not concerned on that. How various judges of this court have viewed this rule in terms of your submission?
Lord, I think for the purpose of participation, there is no judgment. No.
Any other high court in the country has given right of participation to unrecognized trade union?
Not unrecognized trade union, Lord. It's a question. Then I don't. People actually have come across. I have.
V.D. Srivastava, his commentary on Trade Unions Act is considered to be one of the best books.
Right.
There he says, unless some instrument gives right of participation in the meeting, there is no such meeting at all.
Lord, in fact, there must be some.
Ask our librarian to ask them to bring that book.
Lord, there must be some standing orders. In fact, that's not available.
You have to show.
Lord, that's not available. Standing orders are with the management only.
No.
They can only say whether the standing orders are because
where is your effort to secure standing orders?
Lord, what the trade union, what they can do, Lord. If you put just
standing orders are exhibited.
No, they are certified standing orders. Under the standing orders,
standing orders as on date, we do not have with us. But for the purpose of our
where have you ever heard that there are standing orders?
Lord, we have no reference about standing order. Your Lordship would kindly see Annex 1, the way the order has been passed. Kindly see this, Lord. They have given me a so cause. They have given me a so cause notice. I have given a reply to that. They have not even considered that. They have passed an order based on some opinion.
That's all right. Where is your right to be?
Kindly see, my lord. Our right is consideration of our so cause is at least there, my lord. My lord, so I definitely appreciate, my lord. Right of consideration of our so cause is definitely there, my lord. They have not considered that. That is one. Two, they have not even given us a single opportunity before passing this adverse order. Kindly see Annex 1, my lord. Page 23. Kindly see. Based on opinion, they have taken away all our rights, my lord. Kindly see, my lord, Annex 1. No consideration. We have given a detailed so cause, my lord. Detailed so cause we have given. And as on date, if your lordship would kindly permit me, they were kindly see that the document. So
what is the basis as you?
Today I have received some documents.
The number of representatives, worker representatives are more in your favor in your unions as compared to other trade unions.
That number.
How do you say this?
Lord, we have said on affidavit. We have said on affidavit.
The basis?
Lord, that is at page para 7, para 7, page 6. Kindly see, Lord, the document we are filing.
That's all right. We'll look into. But this response is structured on the opinion of the highest law officer of the state.
Lord, can I just clarify that? Lord, Lordship will give me one opportunity, Lord.
Ask the librarian to bring that. Yes, sir. No,
I am sure your Lordship is so well read.
No, so well read. My frugal because I don't have any other business at all. Therefore, I'll go on reading, making my notes.
So well read. I have seen your Lordship reading any time. Lord, today just I am clarifying one thing, Lord. 2016, out of an intra-union dispute of the principal union, and
Mr. Ratho, we have seen now. You take emergent notice.
So I have taken, pursuant to my Lord's order, I have taken. There is a noting that the postal acknowledgement notice is sufficient. AD is not back, but the postal the track report says that it is served.
Anyway, there is nothing
why I am saying,
Heavens are not falling down.
just see the document today I am filing, my lord. They are depriving us from everything.
Not everything.
That's the reason I need, because earlier this type of order was stayed by this Honorable Court.
No, that makes no sense, sir.
But earlier
On
this type
legal
of
basis, there should be some legal basis for that.
But that
Some
is-
judge says something, we will not follow all that.
Lord, earlier, Lord, why I am saying, Lord, instead, can I take your lordship to the basis of this litigation, Lord? But complete non-application of mine, your lordship will find.
So I have seen that. It is struck to not immediately jump to that conclusion. Matter requires consideration is true because the response of the company, industry, is structured on the opinion of the highest law officer of the state.
Kindly see that opinion, my lord.
Yes.
Kindly see that opinion. It's there on record. They have communicated us.
Yeah.
Kindly see that opinion, my lord. Lord, that is
Page
from page
23.
25. Page 25. Kindly see that opinion, my lord. Kindly see it, my lord. I have highest regard for this. Kindly see, my lord. What is the opinion about? This is with regard to JBCCI 9, Delhi High Court passed an order. Then Ministry of Coal passed an order not to allow us any representation. Thereafter, that has been clarified, permitting us to participate, my lord. Kindly see that order. That is the right. Kindly see, my lord, that order of 2021. Whether this document has at all been considered. 21. Kindly see, my lord, that clarification of 2021. Page 203, my lord. Kindly see one just page, my lord. Page 203. Kindly see, my lord. Page 203. This has been clarified. The ban is lifted by their own order. This is not being considered by anywhere in the opinion.
No, but when you have to convince her.
Kindly see, my lord. Kindly.
I will have it.
Your lordship has seen this.
They did.
So in view of this, when the department itself has lifted the ban, which they imposed earlier, and it is not being considered by anyone.
Let them come and we'll hear who appears for that whole company. Who is the standing?
They have a panel of lawyers, my lord.
Just suggest one name so that we'll tell him we'll have this matter on Tuesday, and if they do not do, then we'll do that.
Mr. Sharma. Mr. Sharma. Rakesh Sharma.
Heard learned senior advocate Mr. Ratho appearing for the counsel of record for the petitioner. First, he vehemently argues that in that, just tell your officer, there is such a paragraph which I read wrong below. So he tells us that the union has not only right of being consulted, but also of participation in the meetings of the industrial labor. First of in that connection, he draws our attention to Rule 29Q. 29Q of Orissa. Which rules there? Orissa. What is the name of rules, Mr. Ratho? When you produce rules, the page of the title
I'm giving verification of membership and recognition of trade union rules 1990.
Membership and recognition of trade union rules
94.
90. First he also takes us to the legal opinion tendered by the Advocate General, on which response of the industry is structured. First off, we are of the considered opinion that the other side needs to be heard before passing any interim order. One more sentence. He also took us to the version of the Delhi High Court in a coordinate matter where ban on participation is lifted. First, be that all as it is. First, in our considered view, we need to hear the other side before jumping to any interim conclusion in the fitness of things. First of all, in view of the above, Shri so and so is requested to the learned panel counsel. Shri so and so is requested to accept notice for OP number
4, 5, and 6. 4, 5,
6,
5, 6, 7, 8.
5, 6, 7, 8. OP 1, 2, 3 are
They are the state opposite party.
1 to 4.
learned CGC.
Discussion.
Is so and so on request accepts notice for OP 1, 2, and 3. First one. Next paragraph. In the meanwhile, if any meetings are held, the resolution passed therein shall be subject to the outcome of the litigation. On this matter, on 12 March.
So grateful.
Thanks.
Item 11.
Yeah.
Please, Lordship.
My lord.
Your Lordship is directed to take instruction from the bank. So from the SBI, I am actually
Question our memory.
My lord, in this writ petition, my lord, the writ petition is filed for the inaction of the opposite party bank, my lords. That is the State Bank of India, Jharsuguda branch, my lords. Where in this case, my lord, the petitioner is the second guarantor or second co-surety for the person name called Trilochun Mahanti. He's the principal borrower, my lords. So
is the OP number?
No, he's not a party in this case, my lords.
Why?
Because, my lord, the property has already been auctioned, my lords, of the principal borrower, my lord.
But he is necessary party, na? Any rights which surety, because rights of the surety, liability of the surety is coextensive with that of the principal borrower. Therefore, you impede will direct you.
My lord.
Any relief can be granted to him without borrower.
Millard, his claim is he has given a OTS proposal by virtue of the order of this Hon'Ble Court. But in our record, it is not there. What he says, he is a guarantor cum mortgager, Millard. His mortgage property was put to auction, but it was failed, Millard. Thereafter, bank has taken a decree from the DRT, and now the entire value at approximately 3 crores and above. And the property which has given in mortgage, he has not come with a clean hand. He has sold. Third party interest has been created in that property. So that was Millard. What happened, Millard?
Is there
he is a guarantor cum mortgager.
Understood.
Millard.
We have understood. Whether there is a clause on alienation, is there a condition in the loan document which says he shall not sell the property?
Millard, once a mortgage has been given in our favor, encumbrance created, so he cannot, without the consent,
where is that law?
That will be in the document, sanction letter I can verify from it, but this is always normal conditions.
No, that's not the law. Law is,
Millard,
after the mortgage is made,
Millard,
the right of redemption remains with the mortgager.
Millard,
he can sell that equity of redemption to anybody.
But it's contrary. He has to, in the sanction letter, agreed without the condition, consent of the.
He will not do that.
He will not do that.
But where is that?
That is in the I have not come with the document, Millard. But the guarantor, forget about mortgage. Being a guarantor, he is also liable to pay the entire amount of co-extensive liability with the. Now, when he has sold the property, now there is a demarcation by virtue of the recovery of order. Bank officer went to the Jharsuguda and for verification and demarcation. In demarcation, it is pointed out that the property which has been mortgaged to us, part property has been alienated. Now he is coming with a proposition that I am a guarantor cum mortgager. You release without saying bank is not going to immediately take picture. This is coming through DRT. So he has said that the bank may be prevented not to take. How it can be possible? This is the prayer.
My humble submission, Millets. The Surface Act should be read with CPC, Millets. And Section 11 CPC is explained about doctrine of res judicata. When a matter has been already decided, it decided forever, Millets. So, Millet, when a matter has been already decided at 7,55,000 rupees, we have approached to State Bank of India several times, Millets.
Millard, come to the order.
Sir, 1 second, sir.
but they are not taking any action since.
They are ready and willing to pay back your money.
That is why I'm saying, what is the dues and
what is the amount of due?
Due is 3 crores and something because he's a guarantor, my lord. So it's not like simple mortgager. He is a guarantor of mortgager.
My humble submission is, my lord, the surface, there is a
That is rejected by the apex court. That contention is rejected.
My lord,
This
there is
one I have also come.
2 times auction is there, my lord. There is 2 times auction has been completed, and the auction process, no bidder has participated in the auction process, my lords.
Therefore,
my lords, that's why we have approached before this honorable court. And after hearing of the matter, this honorable court directed to the opposite party, State Bank of India, to give 75,000 rupees. But we have
75,000.
7,55,000.
To consider.
My lord, 7,55,000 rupees.
To consider.
Then, my lord, already
advance amount for considering your settlement OTS, something like that.
It's not provided.
No, my lord, we have approached several times to the State Bank of India. Sir, 1 second, sir.
Now you want money.
Yeah, Miller, we want money.
We are asking you.
Miller.
Are you agreeable with the proposal of the...
No, bank is not, because now property value is 48 lakhs now. Whatever after alienation, if you see, Miller, then that will go for...
You have alienated the property.
That's admitted in the petition.
I'm telling, sir, 1 second.
No, we are asking you. Have you sold the property without intimation to the bank?
My lord, I'm submitting this point. After this, my lord, we have approached several teams to the State Bank of India.
So you don't want to answer our question?
No, sir. My lord,
then we should be heard in the matter.
No, my lord, the thing is that we have...
Is that matter to be dismissed?
The bank official told us...
You are not answering. You should be fair. When you come before the court, you in English, they say stand naked. We have not said that. Means bear. You should bear like everything before the court. This is a temple of justice.
My lord.
Is it not? When you go before the God, though we are not, this is God. We are only pujaris there. When you go before the God, you go with clean hand, clean mind, clean heart. Is it? Now you are approaching this court under 226, 227. Should you not tell the court whatever at least court is asking you? Should you not tell the court? Then we are asking you whether you sold that property. You have sold. Then why we should?
With the permission of the bank.
Where is it? Show that permission. Where have you said in your petition 1 line? Just show it.
I have mentioned in my petition, but there is no written communication from the bank. We have approached, when we approach, they say that...
Where have you said that? We have sold the property with the permission of the bank.
No, through oral communication, my lord.
That's all. Where have you stated in your petition?
My lord, already mentioned.
So that oral permission.
No,
everybody will say oral permission tomorrow.
After 2 times, they told that we are not able to sell our property. So
suppress anything from the knowledge of the court. If you want that other side should not know, you can at least put in a sealed cover and say, we are producing it for your eyes only and not for the other side. That also you can. Where have you stated? Now you have sold the property.
8 minutes.
8.
Right.
Go to 8.
However, the OP...
8. Go to para 8. Where is it? Oral permission.
My lord, however, the bank has advised petitioner that they are not able to sell the property in spite of 2 to 3 times publication of the auction of the said immovable property in pursuant to the said communication on June 2024, my lords.
You sold that property. Where is permission?
The permission that is they orally said was that
Where
we are
stated in the petition.
This thing.
No, we have to put witness box here. Many people, advocates are arguing all outside the pleadings. We will put them in the box for our cross-examination so that we can tear them into pieces. Where have you stated that orally permission was granted, etc.? You are only arguing what is not instructed to you. That's the misconduct.
As for the client instruction, we have that.
No, where have you stated? And did you remit that sale amount to the bank? Or you pocketed it?
No, we are trying to close the loan amount.
No, that you sold it on which date? You have not given the date on which you.
June, my lord, date is not there. So on June month, on the month of June 2024, my lords.
2024.
My lord.
And that money is with you since all these months, 2 years nearly, more than 1.5 years. Then it's why you should not be dismissed with the cost of rupees 10 lakhs. What is the loan amount?
Loan amount is 84 lakh something odd. And now the decree has come for 84 lakh 43,000 along 9% interest. And now the total is 3 crore something.
10%, 8 lakh 40,000 will be the cost. Because of suppression, because of the fraud you have played on the bank. Kindly come to affidavit. The accompanying affidavit. Read your para 3 loudly.
3 and 4.
3 and 4.
Name of the proceeding pending in the High Court in the High Court or would be initiated?
No, in your affidavit. Para 4.
Para 4 statement of facts.
Read it.
As per the contention of this bill, my lord, it's a typing mistake.
Affidavit.
Is the affidavit?
This is an affidavit.
Where is the bail application? We are not bail judges at all.
No, my lord, it's a typing mistake because
Then you should.
How such a long mistake will happen? In typing mistake, some number is varied instead of one word, other is used. We can understand. So absolutely, very, very recklessly, this petition is filed. Your verification, it's a verification affidavit.
My
Contents of paragraph so and so in the petition are true to my knowledge. Paragraphs number so and so are true to my information. Paragraphs number so and so are true to my belief. Barring that, what all you have stated? Where is the verification? Then we have to look into every verifying affidavit. No, brother, no case. The case for dismissal with caution.
my lord, my humble submission is that permitted to withdraw my lord's filing better application so that we can collect my lord more points.
Sold the property, mortgage property you have sold, and you have pocketed the money. That money you should have remitted to the bank. What is your right to take that money? This is a fraud.
So my lord, permitted for withdraw for filing a better application so that I can
We are
collect.
dismissing the petition. We are accepting the. This will not say anything. We are accepting the affidavit as it is, but dismissing the petition with 10% cost of rupees 10% cost quantified at 10% of the amount due. That will be 8,40,000 rupees. That will be added to the account, and you can recover that money also. Take down. Petitioner being one of the sureties and guarantor, having mortgaged the subject property by way of for securing the repayment of debt, he is knocking at the doors of Recruitment for selling the for interdicting the recovery proceedings. First. Learned counsel for the petitioner vehemently argues that his client was ready and willing to settle a part of the loan by selling the security property, which when put to auction, nobody come for participation in. Accordingly, the petitioner sold the property, part of the property, a part of the property in June 2024 with the oral permission of the bank. First one. He also tells that when his client went to the bank with money, the bank did not agree to accept the tender. And therefore, relief as sought for in the petition be granted. Per contra, learned panel counsel appearing for the lending agency, lending bank, lender bank, with equal vehemence resist the petition on the ground that the petitioner has not come out with the clean hands, clean head and clean heart. First stop, a semicolon. These three cleanliness, apex court said, are essential conditions for invoking writ jurisdiction of the court. First off, he points out that at no point of time, any request was sought for, any permission was sought for, any request for permission was made to alienate the security property, and alienation sans permission is in gross violation of terms of loan agreement. First up, he also tells us that the loan account has a huge outstanding of rupees 80.
Outstanding is now 3.2 crores.
3.2 crores.
And decree,
there is a DRT decree for a sum of rupees
83,43,017.
017.
Along with 9% interest.
With interest at the rate of 9% per annum. First time. So contending, he seeks dismissal of the writ petition. Kindly be seated. Sit down. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, this court declines indulgence in the matter, in as much as whatever grievance the petitioner as a surety cum guarantor has, can be worked out can be worked out elsewhere in accordance with law, there being no extraordinary circumstances warranting our interference. First time. That apart, there is a apparent culpability attributable to the petitioner in selling a part of the mortgaged property and not remitting the sale proceeds to the loan account. First one, that virtually is an act of pocketing money of the bank. When alienation sans permission is interdicted in the loan agreement itself. First time. Next point. Learned panel counsel appearing for the bank is right in telling us that the petition is liable to be dismissed even on vague and evasive pleadings. In as much as when the oral permission was granted, who granted the same, and when the sale of mortgaged property took place, and for what consideration, what sale price, are all lacking, all militantly lacking in the petition. First time. They are not just lacking, they are withheld from the court. First, for such withholders, constitutional jurisdiction is not meant for. First time. Next paragraph. In the above circumstances, petition is dismissed with a cost of rupees 8,40,000, being the 10% of the decretal amount. Yes. First, this amount shall be treated as having been added to the DRT decree dated
29/5/2013.
29/5/2013. Sides. Obliged.
But I mean, pardon me, Lord. My item is 58. The phrase admission matter.
Mr. Behura, one second. Whether cost is right or it
Young lawyer conducting the cases.
cost. Where is he gone? The bank officer went to eat a cake now. He ran to the bakery. Is there a bakery part here in your association? No.
Cafeteria is there.
Call his call. Run and come. The cost is the cost. Hereafter, see, we have given showing concession to no cost. He is an youngster. Mr. Behura says it should not be. Even Mohanty appears.
Youngsters from Baru.
You should read one good book. Next time we will ask you questions on canon on banking law. Okay?
My lord,
item 32.
my item, the phrase admission matter related to the recovery of pension from the retired petitioner. After 6 years of
58.
retirement, 58. So I pray, my lord, I may not be reached, my lord.
We'll take it now. Are you happy? Come on, argue.
No. I have other brothers who may angry with me because they see.
It's a pensioners matter, na?
Yes, my lord.
Pensioners matter, so you have to push them in priority because of the apex condition. Pension matters, maintenance matters. They have to be placed above the list above. We'll post it
10th, my lord. Phrase admission 10th. Phrase admission matter, my lord.
How many matters are posted on 10th?
Already 6.
6. Add one more. This one. Okay? On the daily, you make it daily. Bring out to daily list. Okay. Right.
List item 32.
Miller. Say intra-court appeal on behalf of the state, Miller. Wherein the order of the Honorable Single Judge is under challenge, Miller. That is dated 26th April 2024.
Vacancies were available for consideration.
Miller, what happened? This is in respect of the Swechasevi Shiksha Sahayak. And it's the advertisement of 2016.
Whether earlier round of litigation was there?
Vis-a-vis this respondent, your lordship. No, your lordship.
No, Miller.
This is the only case.
This is the only case. And there is a system, so far the guidelines is concerned, there is preference. Throughout the district, he or she has got the choice of preference of which district he is making his choice. So far the first choice, second choice is concerned belongs to Balangir. And therein, she is at serial number 472.
That is for document verification.
So far the merit is concerned, marks is less than the cut-off marks, for which it could not be possible. And the total number of posts is 14,000.
14,087.
087. Out of that, 9951, 9,951 was filled up, leaving vacancy of 4,136.
You are right.
So ultimately it is coming around 14,087. So for the next advertisement, it is carrying forward to the next year advertisement.
But next year means she will be getting burden. This burden.
Well, because the person, those are not coming in the fray. So
That's all
definitely.
right. Did you periodically with a fair degree of regularity you have made
Regularity it is being maintained since last
just
couple
to
of years.
Show that. Where have you stated? We have made periodically.
This is being carried forward. This is being carried forward.
This vacancy.
These vacancies. Because the 2016 vacancies of 4,136
are added to
the next advertisement.
how many? On which year? The first advertisement is 26/12/2016.
26/12/2016.
Show that now. What next advertisement is of which year?
23.
In 2023, it is 20,000.
No, that's all right. But had you held, now what happens to you know? Period we have held in
became overaged. Became overaged by the time.
Where have you given the relaxation? You have not given relaxation for that period also?
Relaxation one case is there. It was extended from 32 to 42.
And 46.
Not that in your rule.
That was in the rule itself.
No, by virtue of the
Order of
law,
OIT.
5 days back, that matter was
correct. No, we are asking you. Though you cannot be compelled to go for, court cannot tell you that you have to appoint each true. But out of 14,087 vacancies, you have filled up 9,951 vacancies. So the remainder was 4,136. Okay.
Yes.
Based upon that, so the learned single judge has worked out some equity, because if that lady is not roped in, she will be out for rest of the life.
But
what was the cutoff percentage?
Well, the present petitioner has secured 169.733. $169.733
in
the SCBC category.
SCBC also?
Yes, ma'am.
This is woman.
SCBC woman.
SCBC woman.
Woman. When
SCBC is a mandal.
Mandal.
OBC.
OBC. When the cutoff mark was 19.
What is the percentage of reservation?
This is 11.25 in our state.
11.25 of notified vacancies, how much it will be? 14087, I calculate. 14087 divided by 11.25.
Divided by 100.
Can anybody help us? Some computer? 14087 divided by 11.25
into 100.
Into 100. How much it will be?
1,25,270 exceed.
1,25,000.
It will be 1,251 posts, Your Lordship.
You are right. Fortunately, you are not made an accountant, but the entire High Court would have been robbed off of the entire money. Yes. That will be
1251 posts.
1251 posts. How many are filled up now? Yes,
Out of 1250,
1251. 1250.
around 1250 or 51.
I
it
mean,
will be
1250. We'll take it at
Let it be 1250 in the round figure.
all. We'll take that way. How many have been appointed?
Well, this has been filled up, filled up.
Is it true?
Because the last was 196.333.
19? No, you can't say that way. You have to tell us out of 1250, how many posts? Because there is a finding by the learned single judge that vacancies are remaining there.
Vacancies, but fact remains, my lord. So far the advertisement is concerned, clause 5.7 specifically, there should be option followed by the merit. If at all the option districts are not available, then others will get the chance. One person can exercise the option out of the 30 districts, Balangir, Keonjhar, Sambalpur, Cuttack, Balesur, like this.
Suppose if a person elects the Cuttack district.
Yes.
And that vacancy is not available to her.
Yes. The second option will be exercised. Second option means second district.
Second district.
Exactly.
No, we are asking you now one more point, incidentally. Whether you did not hold the recruitment process for a period of 8 years.
Right.
8 years you did not hold. And now what is the vacancy position?
In 23, it was 20,000.
20,000. You don't appoint people at all. State does not want to appoint people at all. Yes. There are posts, there are vacancy, and you don't want to fill up.
Lord, state policy, they want to say, it is under this scheme.
We are not East India Company.
This is a scheme, my lord. Guidelines for engagement of Shiksha Sahayak. This is under the right.
In 2023 notification,
yes.
Have you given the age relaxation for those who could not stake their claim for appointment? Now, most of the people will be outside. They have to do some Paripuri shops.
Because,
they are highly educated.
Because at the point of advertisement, as per the conditions of advertisement, if at all they are not qualifying, then subsequent appointment, if there is no relaxation, this cannot be considered.
No. Writ court has to approach it in a different way. Had you given the relaxation of age in the subsequent appointment, perhaps that can be a ground on which basis we could have said that learned single judge may not be right, arguable, may not be right, etc. You allowed people to get the age barred,
yes.
Ensured them to the four corners of the four walls of the house. She is a lady belonging to a CBC. How are you going to justify the action?
Millard,
it has brought about
so far the 16 advertisement is concerned, the age was 32.
Correct.
Subsequently, by virtue of this Hon'Ble Court's order, 32 became 42 for the overaged. That earlier occasion it was also before my lords. By virtue of the court's order.
That is not the stand on which you resisted the petition.
But here,
on that ground, it
could not qualify and the option has not been exercised for a particular district.
No, 1258. Therefore, even that also cannot be. What my brother says appears to be sensible. What my brother says is, this 1250 is out of all vacancies.
It is out of 14087.
15,087
but in fact,
vacancies.
It will be less because left out vacancies is 4136.
4136. 4136 are yet to be appointed.
Yet to be appointed. Which was carry forward to the next.
That we are asking you. Why that carry forward?
Because of the non-availability.
What? No.
Because of number one is option exercise of the district choice. Second one is the scoring of marks.
Did you prescribe a minimum cutoff?
Yes, ma'am. In the process of selection.
Yes. Where is the minimum cutoff?
Minimum cutoff was not in the guidelines, my lord.
How can you say them? Unless you suppose, had you fixed a minimum cutoff?
You can back up.
Either in terms of
Advertisement? Yes.
or in terms of their merit, we would have understood.
My lord, the clause is selection shall be made only on merit.
Correct.
That is on the percentage of marks.
Correct.
So keeping in view the available of candidates along with the option, so those who are available in the particular districts and the marks secured there too, they will be considered. According to the availability of the post also, because district wise it has been segregated. Not that 14,000 post is for district. Out of 30 districts,
Correct.
the total number of post is 14087.
No, you were allocating particular vacancy to the district.
Yes.
Could be contrary to the Supreme Court judgment. That amounts to saying district reservation. Apex Court said there cannot be anything like district reservation. Which is that judgment? Can you take out that judgment?
Yes. In the similar issue also, this Hon'Ble have also passed an order. If you
That is also there pending, the review. Rate appeal and review before the
My
Hon'Ble.
learned senior was the contesting there. Has also been dismissed.
Which is that judgment? Where the Article 15, 16.
That domicile reservation.
Which is that? For state domicile, yes. For district, DP Joshi versus so and so.
My lords.
Is it DP Joshi versus? I do not remember correctly. It appears to be. Just put DP Joshi versus state of Madhya Pradesh, perhaps. Take out that.
That is
DP Joshi versus state of Madhya Pradesh. AIR 1955 SC 334. Go to that particular paragraph.
the recent judgment is Tanvi Behel versus Shrey Goyal.
Tanvir Behan versus
Tanvi Behel versus Shrey Goyal. Reported in 2020 13 SCC page 675.
2020
13 SCC page 675.
615.
675.
675.
I'm sorry, I was not clear.
Which is the paragraph? Read just.
My lords.
Whether DP Joshi is referred to in that document?
It's just opening. It was taking time. I
Go to the
apology.
Now 2020 13 SCC.
Yes.
675. No, 2020 13 SCC, volume 13.
2020.
2020, volume 13. 13 SCC 765. Correct. Equivalent is also given C. Refers to the case of Sushil Sethi. No, you go to that one, no, 2020 itself.
My lords.
Take out that judgment.
The issue was framed. Can I share that?
Yes.
No,
read.
My lords.
Many youngsters are sitting in the court hall. We take so much discussion because we want to learn from them. Perhaps they may also want to learn from us.
The para 15 of the judgment says so. Why residence-based reservation is impermissible is for the reason that such reservation runs counter to the idea of citizenship and equality under the Constitution. It was said as under in Pradeep Jain.
Now, the primary imperative of Article 14 is equal opportunity for all across the nation for education and advancement. And as pointed out by in Jagdish Sharan, Union of India, AIR 1980 SC 820, this has burning relevance to our times when the country is gradually being broken up into fragments by narrow domestic walls, by surrender to narrow parochial loyalties.
Parochial loyalty. Yes.
What is fundamental as an enduring value of our polity is guarantee to each of equal opportunity to unfold the full potential of his personality. Anyone, anywhere, humble or high, agnostic or urban, man or woman, whatever be his language or religion, place of birth or residence, is entitled to be afforded equal chance for admission to any secular educational course for cultural growth, training facility.
That is a matter of education to educational institution, educational institution, admission.
My lords.
But there is a judgment. Go to that DP Joshi versus State of Madhya Pradesh, which relates to very employment itself. I'm not very sure whether this judgment, but there is such a view in V.N. Shukla's constitution, a commentary on constitutional law, student edition. He has given that particular paragraphs. I remember that. Just think of great judge. The great singer from Madras. He retired from traveling for them. Once 3 years he is thereafter he taken a social break after that. This is DP Joshi. Joshi also relates to admission only.
Admission.
But there is such a judgment on
but by this process, teacher advertisement, we are not precluding anybody, my lord. It is clear from kind of a glance to the that particular guidelines, my lord. For a moment, my lord. Very rationally it has been done.
No,
so far the mode of application is concerned.
In any of the districts whom we have selected, whether those persons have scored less than this, just show that.
Less than?
Less than what? 169.73 was said, na?
Yes.
169.333.
Triple 3.
My lord.
The petitioner has secured 169.733.
Correct.
The last cut-off is 196.333.
196.
This is 69.
No. On what basis that cutoff is made? That we want to know. On
so for the merit. That I can produce. Well, kind of a glance for a moment for 53. The mode of application, the heading is. 53 is the relevant para.
Annexure?
This is at annexure.
No, we are not saying for a moment that all those who are in the fray should be appointed if vacancy.
I'm reading for a fraction of a second. A candidate may submit only one application to any of the 30 districts subject to availability of the vacancies in that particular district, irrespective of his or her home revenue districts. The choice of the district will be freezed after the last date of submission of online application. Not that we are saying he or she must belong to that district. Even Cuttack district candidates, like the petitioner, can avail the opportunity of the choice of Navrangpur. No issues.
But other districts are excluded.
No, my lord. He can go for 4 or 5 choice, my lord. Not one district.
No, he can go for choice.
Yes, my lord.
But in case it doesn't come in the choice, then he will excluded.
No. This, my lord, there are, take a illustration of 5 districts. I'm giving my first preference Nabarangpur.
Yeah.
Second district is Keonjhar. Third district is Cuttack.
Correct.
Let it be in that way. Suppose in Nabarangpur district, the person, those who have given their particular choice, according to the availability, they have been selected keeping in view their marks and all other systems.
Correct.
So the persons who is in the last ballot, bottom, definitely the availability of the vacancy will be calculated like this. So if at all that person is not getting the getting it selected for the Nabarangpur, then the second choice comes to, if at all it is Baleswar, then in Baleswar, according to his mark, he can be selected.
No, we are asking simple question of service jurisprudence. You filled up 19951 posts.
Yes.
Leaving 4,136 vacancies.
Yes.
Correct?
Yes.
On what basis you arrived at 9951?
9951.
Why not? We are asking. We are taking it to the extreme. Why not 4136?
My humble submission would be, out of the total vacancy, let it be 100%. 60% is for science category.
Correct.
40% will be arts and commerce.
Correct.
So it is segregated 60%, 40%. Then comes to the qualification, scoring of marks, all other eligibility. Then selection process will be there. Then the third one is availability of the post in that particular district. Then the choice which he or she has obtained as per the guidelines. Then selection will be made. That is the guideline.
No, we want to know on what basis you had fixed the cutoff percentage.
That
we got to say.
Yes.
And because suppose if you fix that cutoff percentage arbitrarily, that will exclude very meritorious candidates from the fray.
Subject to fulfillment of the other conditions.
Other conditions.
Because in that particular category.
No, in that category, we don't agree with that category. The only thing is that suppose vacancies are available, if those vacancies are, all those vacancies ought to have been filled up.
Well, irrespective of choice.
Yes.
Otherwise, that amounts to giving reservation or making the recruitment process that district specific.
That is the mode of application. District-wise list of the applicants as per the candidate's first preference district and other districts in order of preference, and all other information as entered in the candidate will be published in the website. It is a district-wise matter.
In website also you can web post all bad things. So that is no ground that you have web posted something in the website and therefore that should be sustained is no argument. Why we are only asking why you did not appoint 4,136 to the 4,136 vacancies. And you left them for 8 years to accumulate to 20,000. What is the basis?
That I will justify. On what basis 9951 was appointed, others have been left out.
Yes.
Out of the 14087.
That you have to say. Yes. And no other argument because already.
So far the 8 of the judgment, the reasoning is there.
Para 8.
Pilots. The impugned judgment.
Go to para 8. No, what we
the
are
very basic question.
We should not become a bad precedent for the state in other recruitment process. That we are worried. Not just one question.
I will only show their guideline. I will go through their guideline and I will answer your lordship's query. That is my only.
That I have read out, my lord. 5.2. That I have exactly read out.
Their guideline says all the posts has to be filled up. You cannot stop abruptly.
That is 196.333, not 733. Mr. 196.333.
For SCBC, that is
for SCBC.
Yes, one that I have submitted 196.333.
Correct.
Yes, and the mark secured by the petition.
196.333.
You told us 169.2.
No. Petitioner secured 169.733. The cutoff date for the SCBC category is 196.333. Two things more. One is the cut-off mark, another is of the secured marks.
Yes, sir.
Last time I have a
See that, Mr. No.
Yes.
Kindly come to page 86. Your page, paper book 86.
Yes. I'm holding it.
While rejecting the representation, fourth sentence, fourth line, third line.
Yes, my lord. Yes.
While
The secretary.
rejecting the representation of the petitioner, the secretary of the department has held that the engagement of less meritorious candidates than the applicants in other districts cannot create a right for them to be appointed in the district of their preference. In the district of their preference is all right. In other district,
Other districts of their choice.
leave the choice now.
My lord, that
Choice is not available to them, we'll assume now.
my lord, choice is available.
In other districts.
Yes, my lord.
Where is available? If available, then appoint him.
No, my
Appoint
lord.
her.
The person has to go for a choice. 1, 2, 3, 4, 5, my lord. Not single, my lord.
Next sentence, kindly read next sentence.
Yes, my lord.
Most of that.
It is not known.
It is not known. What was the cutoff mark in respect of each of the 22 districts under the SCBC category? Reference to the guidelines by resolution dated so and so reveals that there is no provision for fixing any cutoff mark.
At the threshold, I have said, my lord.
Then you have absolutely.
My lord, so far the availability of the candidates on the vacant post, definitely who will be the higher, so far the mark is concerned, he has to get the.
No, go further.
Yes, ma'am.
Not that single judge has taken note of everything. Go further.
Yes, ma'am.
The process of selection, as would be apparent from reading of class 5, is that it envisages multiple rounds of selection till 100% merit list is reached or all the candidates are exhausted.
And when they exactly, my lord says, harp on the point, why these 4,000 posts have been left out. That I will clarify by.
Yeah, let's say. No question of clarification because the notification does not give you discretion to cut off.
No, my lord. Once it has been done in 2016, subsequently carry forward, and 20,000 vacancies, it has been advertised also already in 2023.
If I may also be permitted, I'm sorry.
There is nothing in the guidelines suggesting fixation of cutoff mark. That may be extreme, but anyway, if that is accepted, even those who have failed.
I have not failed.
No.
They have.
We are giving a notional point that those underperformers who cannot answer one single question,
ineligible,
even they have to be subject to fulfilling eligibility.
If I'm ineligible, your lordship, the question of
ineligibility is another thing. Because you are eligible to be in the fray.
Yes, sir.
That does not mean.
And for that,
all should be appointed, maybe an extreme point, but there is some sense.
Because they are
she was placed in the serial list of 472 of the Balangir district. That also I was something.
So kindly, allow me for 2 minutes.
I will full allow.
Telling us to us.
No, your lordship. No, your lordship. I will not dare to. The 5.10 of the guidelines is also very crucial, your lordship. 5.10
that
and
is
5.11.
That is
even displayed.
That is reproduced by the learning.
Yes,
87 things.
The 5.10 says step 5.6 through 5.8 constitute one round of draft merit list. In each round, there is possibility of reduction of candidates from draft merit list due to absence of rejection during document verification, thus reducing the draft merit list to less than 100% of vacancies. To make the draft merit list 100%, step 5.6 through 5.8 will be repeated, discarding absence and rejected candidates from previous draft merit list. Now 5.11. In each round, few candidates may be deducted due to absence or rejection. Preparation of draft list will continue until finalization of 100% merit list or exhaust of all candidates.
But all candidates ought to have been exhausted till all vacancies are exhausted. That way.
The Honorable Single Judge held that you have proceeded the recruitment process through a resolution and you cannot change the game midway. I am not saying I have a accrued right to be appointed. but on the basis of the notification which you proceeded, the recruitment process, I have a vested right to be appointed because of the guidelines you have given. Had it been the case that you made out an executive instruction that we will not fill up this post because of the lack of meritorious candidates, but this is not the case.
As my lord asked you at the very first, is it that this 169,333 cut-off mark is the mark below which any other district anybody has been taken?
My lord, the answer has to be yes, because
Yes.
in the learned secretary has said that way. He says merely because her performance is better, she will not get the rate. This is obnoxious. Obnoxious. You are choosing the teachers, not some chaprasis. While choosing the teacher, the comparative merit should be the factor. Though merit is not the mantra, said Supreme Court. Anyway, that is so far as SCBC, SCST and other things are concerned. But when it comes to from state category, merit is the mantra.
When the list is prepared as a whole, then definitely that concept. When it is being prepared district-wise, as per the scheme.
One thing, the ground on which learned single judge has structured the judgment appears to be absolutely correct. Except one that he
100%. It is the practice.
Because some satisfactory requirement. Suppose for a pilot, there are 100 posts of the pilots. And many, including Dixit, also participate, saying that I have experience of so many years of judgeship. And they reject me. There are vacancies are remaining. I cannot contend. There are still vacancies and therefore appoint me as the pilot. Because that will be disastrous to all including Dixit itself.
Age and other factors are there.
So many factors. Therefore, that may be an extreme example. But in the conspectus of the facts of the case, what the judge has said appears to be sensible.
Because as a whole, because series of other matters are also there.
That may happen. What we bring
here let me come with the affidavit. So far, this left out candidates 4136 is there. On what basis? This remaining part has not been filled up and it has been carried forward. So far, the 4136 is concerned.
You said that because it was on the basis of option discharged by the candidate.
Yes, because it is district-wise.
Cannot take it district.
That is the mode of application. Beyond that, I cannot travel, Miller.
That
is contrary to the well-established jurisprudence of the country.
Page 53. This is very well available, Miller. Page 53, clause 5.4 and 5.7.
You cannot accumulate vacancies and one fine day auctioning all that. That we don't agree. They are accumulated with some clandestine design. That's our experience. Therefore, courts have taken the view, periodically appointment has to be done. Otherwise, all will become time barred, age barred, where they should go, unless you give relaxation.
Relaxation so far the age is
concerned. At least for age is concerned. That is not your case. You have not given relaxation in 2023 notification also.
23 notification, this is not available, but 23.
No, I have seen in other matters which came before me.
23.
For us, we saw.
Enclosed in the writ appeal.
23.
Page 9, that is the page 95. Answer 7.
That is relaxation, age relaxation.
May not age relaxation, the advertisement.
Many more things will come.
Many more things will come with it.
Maturity of young persons will pour in.
What they will feel? They feel disgusted that for no fault of theirs, because we cannot bring stay against the run of time. The aging cannot be halted. Aging takes place. Where should young minds go? It's a serious question.
Even if they will get, the youngsters will be also deprived.
No, that is not the question. It is as between, those who otherwise are entitled to be in the
except age.
You exclude them by not making the appointment, by not undertaking the recruitment process.
Freshers will be there. They are not there. It is only who will be.
They are also they are in the market. The size of the market increases. That's all.
But when youngsters will come, definitely age-bad persons will
Exactly. So many
will not get a chance.
It's not only as bar.
That only weakens your, that argument weakens your stand. No, brother. I think we agree.
So let me give the instruction to that. It will clarify me because it is.
You should have done it before the learned single judge. I can dismiss the agreeing with the reasoning of the learned single judge. Yes.
Item 33.
I'm much grateful, Your Lordship.
Yeah.
State has filed this.
Yes, Mr. Mohan.
33, it is a matter of regularization, my lord. The impugned order is at page 29. Be there.
Right to job is right to property. Right to public employment, subject to certain conditions. Is right to property. Job is a property. But from there, income is generated.
The results are on Supreme Court also reiterated in a decision, my lord. That particular court. Yes. It's, well, it's in that matter, may take, because it may not be treated as a precedent, my lord. That means because 2016 advertisement. 2016. That may not be precedent because 2016 advertisement. Now we are in 26 and 23 advertisement. They have been appointed also. Thereafter also in 24, 25 advertisement was made. Because many other persons taking the advertisement because 2016 advertisement. Amounting of opening up floodgates because it yes specific that will be another point.
Yeah.
Here, my lord, there is a question of regularization, my lord, of the quick come attendant in the.
How many years of service?
This
First
is
point.
2007.
18 years service.
2007 appointment.
What is the post?
Post is cook come attendant.
Cook. Any complaint that he or she did not cook well?
No, ma'am. Only ground is no sanction post. But the recent development so far, the starting from Jago to today's so I cannot advance more, Milan.
How many years after the date she approached the learned single judge?
Now he has completed.
This is
now he has completed 18 years.
This was 13 years somewhat.
From 7 to 2026.
Even now continuing.
Yes.
Continuing.
Yes.
Without orders of the court.
Without orders of the court, is continuing.
If without orders of the court, then has to be counted. People become hungry. Every day we have hunger. Naturally, every day we have to eat. Therefore, you can't say we don't need, there is no requirement of the cook at all, unless you yourself cook, which you cannot undertake. For other things, we can understand.
Under the SCST.
And those who cater to the daily requirement of human being. The argument that we don't need them may not be, that will not be sustainable argument. Because every day we get hunger, unless we are not Amrita Putras.
That is inevitable. We have to.
Inevitable. But better. State and its officials are knocking at the appellate court in this intra-court appeal for laying a challenge to the Internet Single Judges order dated 13/11/2023, whereby respondents WPC number 2088 of 2023 having been favored, the relief of regularization of services has been accorded. First, next paragraph. Learned AGA Mr. Mohanty in his usual style argues that the regularization could not have been granted by the learned single judge in view of a decision in State of Karnataka versus Umadevi and the summary of those rulings. First off, he also tells us that the learned judge failed to take note of the fact that there were no sanctions posts nor vacancies, and therefore question of regularization could not figure in the case at hand. First off, learned counsel representing the respondent employee opposes the appeal, making submission in justification of the order of the learned single judge and the reasons on which it has been constructed. First off, he tells that Duma Devi is not the destination point of law of regularization, there being march of the law by virtue of Jago, Sripal,
Dharam Singh, third one is Dharam Singh.
Latest is Dharam Singh.
No, latest is Pavan Kumar.
In addition to that, there are some cases of our this court which has been confirmed by the all apex court. Those are
My lord, latest one is Bholanath and Pavan Kumar.
All belongs to the Jago case.
He also contends that the arguments that posts are not available itself is not available in as much as the job seeker, the respondent is a cook, come attendant. First off. Next paragraph, having heard the counsel for the party and perused the appeal papers, we decline indulgence in the matter in as much as the petitioner, the respondent employee has already put in a long and spotless service of 18 years without protection from court orders. First off, a person who has been continued in service for decades ordinarily would get the right of regularization in the light of the decision cited on behalf of the respondent. First off, this aspect having animated impugned judgment of the learned single judge, there is the least scope for it for our interference in the matter. First off, even otherwise the impugned order has brought about a just result in the circumstances of the case, and therefore its sustainability stands not demonstrated, regardless of some arguable infirmities this side or that. First off, in the above circumstances, appeal being unworthy of benefits is liable to be rejected, and accordingly it is giving a period of 8 weeks for implementing the impugned order, failing which the appellants may run the risk of being hauled up in contempt of jurisdiction.
Fixing to 8 weeks.
No course. 8 weeks. No course. Yes.
Item 34.
Shall I write this previous court's judgment, Your Lordship? Writing piece of paper.
Give it.
No, you give it. I'm just that. You give that judgment. That paragraph just producing how they have jurisprudentially developed that from right to employment to right to property. How the law has developed. Give a small note. We'll write your name also in the judgment. Yeah.
Our High Court has also delivered a judgment on that regard. Our High Court.
Okay.
I'll also give that
judgment also.
Then should I submit a note of submission with the
You go to library and bring one note small immediately. Write out and bring it.
With the photocopy of that.
I'll do that.
In item 34, I am for the opposite party. In the meantime, there was an amalgamation of the Utkal Gramya Bank from Odisha Gramya Bank. Amendment has to be carried out. I have given the notification.
In the meantime, it's long since.
No, it's not last year.
Last year.
Last year, April.
Yes, we have already gone through 1, 2 cases.
Why amendment? Whatever order we give here will be applicable to you. You are an amalgamated entity.
No, I have to bring it.
The other my lords has given that Gramya Bank is Gramin Bank by virtue of the amendment.
This is
day before yesterday.
Completely another Gramya Bank has amalgamated into another Gramya Bank. That's why I have brought it. That is the reason. That nothing more. Had it been Odisha Gramya Bank and Gramin Bank, I have nothing to say. That is the thing.
Separate in the learned panel counsel appearing for the respondent. You are respondent. Appellant.
I am for the
respondent. Submits that the Utkal Grameen Bank, as it then was, having been amalgamated into a new entity, namely
Odisha Grameen Bank.
Odisha Grameen Bank has come into existence, and therefore the cost title has to be accordingly amended. First of all, we agree. Appellant to carry out this amendment.
By tomorrow I will do. By tomorrow I will file the amendment petition and consider.
Within 1 week. Within 1 week. Call after 2 weeks.
Item 35.
You do judgment.
Millard, in item 35, related to Madam Patnaik, may I take next week, Millard?
Madam was here, na?
No, here.
The request now, run it each. Yes.
Item 35. Next week, paying a coach. Or similar reach. No.
Covered with similar judgment. Then no, next week give it. If it is covered, we will not grant any time to anybody. Identical matter.
My lord, may kindly pay to the previous order also. I have already given all the judgment also in that. The said already been dismissed by Apex Court. Catch up cases.
Identical matter is affirmed by the Apex Court. In which identical matter?
These are all demonstrators. Let me check the things. May I prep on next week? I don't prep for a long time.
Yes.
Item 36.
Please, Your Lords.
On the group of District Court kindly adjourn this matter to next week.
Sister wants right.
Sort that, my lord. No, because retired junior serving got the promotion, my lord, that one.
Let us. Yes, get the request now.
Item 37.
My lords, item 37 to 41 says allotted to Mr. Ponda. He has some difficulty.
27 to 40.
40 and not 50.
We come to which?
Sorry for next week.
Next week.
That is forward matter and name it to be number it to be changed. Nothing into that is same one or a common word.
Order, your lordship, in one case, your lordship, Allah. It is
allowed already.
Your lordship, that is your lordship, kindly see.
You that?
40, item 40.
Show to bear
Item
40.
My lord, 40.
Yes, Mr. Bear, I remember. This is covered by the judgment.
My lord,
That is only thing is,
my lord, that is
serial number.
Common order, your lordship. Kindly see. I am Dhirendra Puhan in respect of Sharat Chandra. That is in the Indian order.
In respect of that, we have already.
My lord, good like you. I have also corrected only.
He has corrected numbers also.
My lord.
40. Corrected as it is. Yes, yes, total.
Item 42.
41. Next one.
Mr. Carr is waiting for what?
Item 41, I am for the respondent in the first item.
41, it appears Panda, Mr. Beura says Panda's allotment.
Next week only.
Next week? Next week? Well, next week. At the request of the AG.
Can it come to the supplementary list? Your appointment, recruitment has been stayed for the last 2 years.
2 years?
2 years.
52. Well, yeah.
May please not say.
Yes.
Odisha Grammar Bank is the writ appellant selling the order of the Honorable Civil Judge. But here, before I proceed, there is a delay of 7 days.
7 days. In control delay, whether notices are
Yes, already. And
who applies for the OP?
Mr. Abhiram Swai.
Where is he? He referred after a short delay of 7 days. First of an application supported in IA number so and so supported by affidavit accompanying the appeal memo. First of explanation, delay being short and the explanation being plausible, comma. Application is allowed and delay is controlled. Your friend is not here.
Not here.
Let him come. We'll have it next week. Next week.
But here, my lord, at the time of issuing notice. My lord, may I pardon? At the time of issuing this, my lord, there was a content proceeding pending. But my lord said since delay has not been controlled, they can mention that
37.
The contempt, the pending contempt proceeding shall not be precipitated by the respondent till next date of the call up to 3 weeks. Call up to 3 weeks to enable consent for the respondent to come and argue. Yeah.
Item 43.
In dealership, here I am for the respondents. I think Mr.
Your friend is not here. Any covered matters you have? Any covered matters from any one of you? No. Yes. No. Don't take away others' file.
I'm sorry. Your Lordship has directed to file an affidavit.
Yes.
Giving the list of persons who have not attained age of 60. Filing that affidavit.
In which item?
43 minutes.
43. Go to the interim dot.
Before that, Lords, you can see order number 2, that is dated 26th of June 2025.
Go to order number 2.
2. That may touch to the point involved. Your Lordship has pleased to observe in a way. That is also the issue where it is to be answered first, thereafter the other things.
What is the grievance? List of members.
Yes.
Lord, they were coal handling workers. And when the system changed from coal handling to other type of engines, these persons were terminated. They were contract laborers.
How long they had put in service?
My lord, varying from around 10 years to 15 to 20 years.
But suppose if there is a technological change,
Yes, my lord.
What they should do? Suppose tomorrow everything computer decides, then there will be no requirement for the judges at all. Can we say, no, you have to retain with you? If technological advancement takes place, where you become non-utilitarian, it is a case of who moved my cheese.
I understand.
How can you compel them to take you?
No, let them take instructions. We had this honorable court has asked them to whether they could.
Not anything can be done, brother.
No, sir.
Maybe explore that.
Let it come some other time, my lord. If it is possible.
To explore whether they can. Now, if you say they should go somewhere, where they should go? They have to jump into Mahanadi.
That
Poor persons, my lord, they don't have any other alternative.
But as I have prayed lordship, the order of 2 itself says again the maintainability. This, they are to answer also.
No, that will examine.
But the other part, the accommodation issue is concerned. So,
Only thing that, my lord, these persons do not have any other recourse.
You have said that, no?
That is why.
In that score, I have to take a specific instruction from my department only.
Learned senior panel.
Lordship, that
Senior panel counsel. Our request agrees to explore the possibility of absorbing the respondents, appellants.
I am going to respond in this case.
Of members of the appellant association in some avenues, so that they can have some succors. Always. We go to next.
Let's take up. We're waiting that.
170. Item 170. RACP matter, my lord, the single bench has already passed the order to implement the government order that has been challenged by the Cuttack municipality here after 484 days delay, my lord. Race admission matter that has been listed in item 117. May be taken up next to or which chapter? Since implementary senior clerk.
No, let us.
Lordship, may I mention
7 supplementary because the retired person is not getting pension.
Not getting pension. 52.
47.
Your Lordship, may I mention item 44? I am for the appellant. It may come up tomorrow. May I pray for the next week, Your Lordship?
No, what's the urgency?
No, I'm not praying for any urgency. Since it may come up tomorrow, that's why.
No.
49, my lord. Recruitment of 2020. I have this on directed for appointment, the single bench, my lord. But subject to medical fitness, my lord, I will examine and the medical board has declared me fit, my lord. Still they are not giving. You already had it once, my lord.
Week of
next week.
Yes. So that item 44. I may press that can take on 1 week after my 44. But my friend is mentioning. In the meantime,
next.
52 serials. So that's why I.
In a way, my let's pass the interim order.
In 42. In 42. Not interim.
He was not there.
You were not here.
Since content petition is there.
No, I'm not seeing any content because the final hearing will be before my order.
Let us some order we have made now in that.
Yes.
Yes. 46. Let's see. 46. What is the matter? Urgency.
The village road has been taken by the person, petitioner, and while the revision is pending, it came before the Honorable High Court. Honorable High Court said since the revision is pending before the collector, dismiss it with a cost of 500 rupees.
5,000.
Order, he
5,000.
challenges me for your writ appeal. Now he's protecting that village road should not be completed because entry point which all people are facing problem. 46 to
After 2 weeks. How long it is like this?
Let's see the immediate work of next week.
Okay.
In the supplemental.
No. Yes.